in Commerce, featuring NTT, New Trust Technology. Presenting your host, Chrisitian Walters.
Welcome, everyone, to this Tuesday, January 1st, 2000 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Chrisitian Walters. Welcome to NTT as New Trust Technology. And this is Tuesday, just a general Q&A, so if you want to, we'll be starting a Q&A shortly here. So we'll go to the disclaimer now. Take notice and acknowledgement with agreement that this show and/or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute
Unmuted.
and/or guidance by a licensed attorney. This private show and/or documents are for academic informational purposes only to be used at your own risk without liability to Chrisitian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Chrisitian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and/or using this information, you acknowledge and agree that you are not a client of Chrisitian Walters. These documents and/or show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Chrisitian Walters' discretion. Thank you for your understanding. Okay, welcome everyone. Saturday we went over Remedy at Law was the title of the show last Saturday, and Monday we went over on the Trust Ambassador call a review of that and had an excellent discussion. And the topic for that was, how do we get into a court of equity to get a remedy? And I'd like to continue that discussion on tonight based on Corpus Juris Secundum, Book 30A, under the title Equity.
If you'd like to ask a question, please press 1 to add yourself to the queue. Otherwise, press your request has been received.
Discussion is, how do we get into equity, a court of equity, to get a remedy? And just for a quick review on some of the points under Section 17, that the adequacy of a remedy at law is a line of demarcation between courts of law and of equity and is strictly preserved. And the touchstone for equity is the lack of an adequate legal remedy as discussed in sections 18 through 20, and equity is inversely related to the scope of the available remedies at law, and furthermore the line between the law and equity is not only sharp and distinct, but is also variable and changing. And now section 18, lack of remedy at law as ground and limit of jurisdiction. A general rule, the inadequacy of a remedy at law, and that is really the ground, is both the foundation of and conversely a limitation on equity jurisdiction. And unless a legal remedy is made exclusive by statute, generally, equity may be stated to have jurisdiction in cases of rights recognized, and protected by the municipal jurisprudence where adequate and complete legal remedies cannot be had. In other words, the touchstone for equity is the lack of an adequate legal remedy.
the touchstone for equity is the lack of an adequate legal remedy. So it must be alleged by facts into evidence demonstrating in order to get an action to enforce. So that, again, the touchstone for equity is the lack of an adequate legal remedy. And to invoke the powers of a court of equity, it has been required that it affirmatively appear from the face of the pleadings and from the evidence. And the plaintiff has no adequate remedy at law. And where cases present such complications, and that complications would be no adequate remedy at law, so continuing on, such obstacles to the disposition at law and such questions peculiar to equity as to make it manifest that a court of law could not so deal with it as to effect a proper adjustment and bring about a complete termination of the contention, equity has jurisdiction. Conversely, equity will generally not take jurisdiction where there is an adequate, complete, plain, and speedy remedy at law, unless it is shown that there is some feature of the case which is peculiarly, there's that word again, within the province of the court of equity, or unless special jurisdiction has been conferred by statute, or unless it has been held by some special and substantial ground of equity, jurisdiction is alleged, and if necessary, proved. So this general rule has been embodied in some statutes. Its application necessarily depends on the factual circumstances in each case. And this consideration, the phrase adequate remedy at law, quote unquote, has been said to be a legal term of art having a settled and well-known meaning in equity jurisprudence as referable to the remedy for damages in a civil court. And as the rule is sometimes stated, equitable remedies cannot be pursued until legal remedies have been exhausted. And ordinarily, a bill in equity cannot be maintained to obtain precisely what plaintiff can secure by an action at law. And the theory that the rule that equity will not take jurisdiction where there is an adequate remedy at law is to be taken as indicating the origin of equity jurisdiction and as defining generally its grounds and objects. Grounds and objects is more generally adopted that the theory that the existence of an adequate remedy at law is a constant limitation on the exercise of jurisdiction. Where the latter theory prevails, the court is adopting it, have generally been influenced by statutes in terms restricting equity powers to cases where there is no adequate remedy at law, but in other jurisdictions, such language in general statutes is held to be merely descriptive of and not intended to restrict equity jurisdiction and is not precluding the broader doctrine. The rule that equity will not grant relief where there is an adequate remedy at law applies only when, on the case stated, there is a legal remedy. A distinction is to be observed between the case cognizable at law for which the law has no adequate remedy and a case that can be decided on the merits only in a court of equity. In the one, equity court is invoked only for a remedy, and the other for an adjudication of rights of the parties on the facts. And where the suit is properly cognizable in equity, the existence of an adequate remedy at law may justify a court of equity in refusing to entertain the matter. Where the matter is legal in nature, the absence of an adequate remedy at law is necessary to confer equitable jurisdiction. If on the facts stated, the case is of a nature cognizable only in a court of equity, plaintiff will not be shut out of a court on the suggestion on the other state of facts he might recover that which would be equally satisfactory in another tribunal. So failure to specify request equitable remedy, and then there's the borders and cases and discretions, and then there's the invocation of equity jurisdiction by the defendant, and that The last section is the avoidance of substantial and irreparable damages, and that ends sections 18 that they were making reference to earlier, that the touchstone for equity is the lack of an adequate remedy, legal remedy, as discussed in for sections 18 through 20. And I'd like to kind of tie that in with preceding that in a prior section, section 9, going back, and that section was ancillary and incidental jurisdiction. And generally, a court of equity has jurisdiction of a suit ancillary to a suit of which it has previously acquired jurisdiction, and such court has implied powers to do whatever is necessary to discharge the function placed on it by law. Now, that word discharge, in the way it's worded in with this little paragraph, I think can be taken to mean one or the other, depending on which side you're interpreting from. It's relative from your position. So let's get a definition of ancillary in Black's Law. Black's Law, 8th edition, ancillary. Ancillary Black's Law. Ancillary, supplementary, subordinate. What else we might have here? So ancillary, supplementary, subordinate, ancillary claims. So remember, something is subordinate to or supplementary to. Subordinate. Maybe we ought to go to subordinate and see what that definition is. Black's Law, subordinate. Subordinate, adjective, placed in or belonging to a lower rank, class, or position, subordinate lien. 2, subject to another's authority or control, a subordinate lawyer, for example. And now subordinate as a verb, to place in a lower rank, class, or position, to assign a lower priority to, subordinate the debt to a different class of claims. So I think it's subordinate. It's kind of like a portal, or ancillary is a portal word. It could be taken to be that it is one of a lesser claim, or it could be one that is in addition to. Okay, so we got a working definition of ancillary. Now, continuing on in section 9, generally a court of equity has jurisdiction of a suit or a proceeding which is ancillary to another suit, or a proceeding in which the court has previously acquired jurisdiction, even though under some circumstances at least the court would not have jurisdiction of the ancillary suit or proceeding if it could be regarded as an independent and original one. Jurisdiction of an ancillary suit or proceeding is referable to or dependent on the jurisdiction of the court of the main or principal one, and jurisdiction of the ancillary suit or proceeding ceases if the main or principal suit is terminated, that's a trust term, or dismissed for want of jurisdiction. Even though a suit is ancillary, it does not follow that it will be entertained by a court of equity, nor is its form necessarily determined by that of the principal suit. In this connection, an ancillary suit may be equitable affecting or in aid of the suit in equity, or may be legal affecting or in aid of the action at law. and where jurisdiction of cases in equity and cases at law is vested in the same court, the ancillary suit may be equitable affecting or an aid of an action at law, or it may be a legal affecting or an aid of a suit in equity. The form of an ancillary proceeding must be in accordance to the facts, and it must be a proper proceeding adapted to the nature of the demand. And I might go to the next one, incidental jurisdiction. A court of equity may properly consider a bill which primarily seeks relief in such a court may give and also seek other relief which is incidental and germane to the principal or primary relief sought by the bill. Courts of general equity or chancery jurisdiction have implied powers to do all things necessary to discharge the functions placed on them by law. So, does that possibly state that we can discharge any claims at law if we bring them in right, even though that they've possibly made a first suit, which would be ancillary to the primary one, which would be the one in equity? Now going back, we could move forward, but maybe that's enough on the plate so far. So if you want to ask a question, join in the queue, get in line, press star 6 and star 1. Press star 6 and star 1 to get in the queue. And we'll open it up for discussion. Hi.
Hey, Christian. I have a question for you. I guess a hypothetical scenario. Don't know how it's really related to what you just talked about, but maybe you'll entertain it all the same. In a situation where you have an individual that was, let's say, in an automobile accident that is not knowledgeable about anything to do with trust, but yet they are being taken advantage of, say, by the other party's insurance company and not paying for damages and or medical, whatever the case may be. Would it be proper or an option for us to help them to do the claiming of the trust, transfer the titles, gather up all the NOI, SOI material, to take it to equity, and
Who's the trustee on the case?
Be there
or
to
the,
speak on their behalf, having been appointed a co-beneficiary? Or would you need to be appointed a trustee in this case so that they could order you and then you would order the
co-beneficiary
opposing
would be
insurance company,
could
so
be
to
able
speak?
to stand in for the other one.
Well, I would think that we would make the insurance company the trustee, and the beneficiary thereby could direct them to settle the matter. Yeah, and the judge, not being the trustee, would direct the trustee, being the insurance company, to settle the matter.
Suppose that the beneficiary was another trust.
More than likely, the judge would not.
And the trustee on that one,
I guess, query the
supposing that scenario,
unknowledgeable
was
beneficiary
the co-beneficiary
with regard to trust.
In your first scenario,
you could intercede on their behalf as their spokesman to answer any questions he may have and to make any.
Who is the beneficiary? So this second trust would be beneficiary.
Okay. So then as the trustee
the
of
beneficiary
the
would be the
trust,
beneficiary would be the
you
trust.
could go,
And then the trustee on that
I'm sorry, say that again?
trust would be the party that you're talking about that you want to come in
Right.
and on
So you
behalf
could go
of
in
that
on
person
behalf
speak
of
for
that
them.
second trust and
Now
order
the
the
trustee over that beneficiary trust,
case
and
to be
they
settled.
absolutely would have a right to come in because the trustee's got a duty to defend that trust for the benefit of that beneficiary. Yes, because maybe in the court they would want to see you
Right.
not to be a
Yeah, I can see
beneficiary
that.
and be, say, grantor also. And that would be a way of getting around that.
Okay, so that would take any requirement of the original beneficiary from having to go defend it.
No, not on that one, no. Yeah, because the trustee on the
Right.
first trust is going to be grantor, granting in to, say,
Now, in this scenario where you're the
for the
trustee for
beneficiary
the
who
first
is the trust.
trust,
And,
would you
and that
also
trust is ultimately
be the
for the
grantor?
beneficiary, that other party.
Okay, so they would be the grantor that
Right.
so the original person that I would be trying to help would be the trustee and grantor of that
Well,
trust.
you'd have to have some kind of
And
right
then
to...
I would be, for example, the trustee
Well, let's put
on
it this way. Beneficiary
trust
of
that
the first trust could be the
represents that
grantor
first trust.
for the second trust.
And I could actually be the grantor of that trust, right?
And you would be the trustee
As well?
on that trust for the benefit of the beneficiary on the first trust.
Or in that. Right. Got you. Yeah, that makes sense. So you could apply. Right. So you could apply this trust approach to most any
Yeah,
situation.
I would think so. But
Another
we'd have to
example
probably
being
check that out
you
a
have
little further
a
and make sure that we have
current spouse that is
left
owed
something out.
spousal support from a previous spouse, and you could set it up in a trust scenario, and then you could go into equity court representing that spouse to
Anything on for topic
order
for
the
tonight?
settlement of the case.
Okay. So let's get on a discussion for the topic being how do we get into a court of equity
Okay.
to get a remedy? Next caller.
No, other than that, not.
Billy.
If you'd like to remove yourself from the queue, please press 1. Otherwise, your
Thanks, Christian.
request has been removed from the queue.
Here's a question. There's a traffic ticket that says pretrial waiver and prepayment instructions. Then down in the instructions it says write down the amount to be paid and any special instructions.
Well, that kind of leaves it open, doesn't it?
Yeah, right.
You got a Mack truck you can drive through that?
Yeah. So I'm thinking that now in equity, since we're talking, we want to go in camera. In chambers, there is no trial. So it says pretrial waiver and prepayment instructions. So, you know, it depends how you read it. It sounds like it's an invitation. They're advertising for some type of trust, if you can form a trust.
Mm-hmm. Yeah, I'd be driving Big Bertha right through there. Big Bertha Trust, yeah.
And this is a standard municipal, you know, police form thing.
So how do we get in the court of equity, get a remedy?
Well, we form the trust, and then we can use, we're going to make a deposit of the ticket, direct them to pay for it. Should they fail to comply to the terms of the trust, breach of trust, we then can go into equity, have the matter settled in chambers. Because we're coming in equity from the beginning. We're not coming in on the statutory side.
Okay, what actually do we have to have, say, the necessary elements to claim to get into the equitable side? Or what would be the devices that are necessary?
Well, you have to have a proof, as you have to have a bill of equity, a proof of the breach, and I guess proof of the trust, and a proof of the breach of the trust. Could be any of the maxims. We could even say it was well, we couldn't say a mistake, but I would think it would be one of the maxims.
Yeah, something I thought of after the show the other night was that on page 180 of the book it says applicability of maxim. It says the maxim that if there is no remedy at law, equity should act. That's a maxim. And now what would you do with that maxim? How do we invoke a court of equity? What is the particular grounds that's going to invoke this special substantial jurisdiction? Saturday, Monday, and tonight. What is the main thing that should stick out? What is the touchstone?
Well, I thought that from last night's conversation was, to me, it's not about not having a remedy at law. It's like a bait. They're baiting you to go into the other side. But if you start from the beginning by saying this is all equity, and these are my standards, these are my maximum standards by which this trust is operating, this special trust is operating, and there's a breach, that just seems to be axiomatic because equity deals with breach of trust. There's a breach of a trust that falls into the realm of equity.
Okay, we also have on the board Jacob and Michael. Unmute those, and we'll get them into the conversation here. If anybody else wants to join into the queue, press *6, *1. All right, you're unmuted.
We would be moving the titles. We would withdraw the general from the general and move it into special deposit, thereby creating the ability to go into in camera and expressing the trust and putting forth orders for the judge to do, along with the UCC1, UCC3, of course, and the county.
Okay, that would substantiate the SOIs or the evidence to get it in chambers, but how do we invoke the court of equity?
Christian?
Jacob, go ahead.
Well, we would definitely want to be able to express the trust. And we would do that with the NOIs.
Okay. What is this whole section I've been talking about, you know, the main focus over the last 3 nights? What is the touchstone for equity? How do we invoke a court of equity? There's 2 possible things here. What's equity all about?
Justice and fairness.
Protecting of rights. Protecting of a right.
Right.
Special deposit.
About rights. Equity's got to be about rights. And they got to recognize those rights. Why do they have to recognize those rights?
Because in CGS Section 2, equity deals with the natural rights given to us through the Godhead.
Okay, what's going to keep us out of a court at law? What's going to get us into equity? What's going to invoke the court of equity and not invoke the court at law? Rights is one of them.
Well, when we can't have a remedy at law.
Okay. Now, what is the exact thing I've been quoting all these last 3 nights here? A particular catchphrase, quote unquote. A lack of adequate remedy.
Lack of adequate remedy.
There is no adequate remedy at law. So there has to be, under this case, actions to enforce, where it said that the villages was a complainant, I guess. Their action seeking to enforce provisions of a pre-annexation agreement was improperly dismissed under the theory that the amended complaint was deficient. It was deficient because it did not allege facts demonstrating that the village had no adequate remedy at law. How do you invoke a court of equity?
Produce evidence that you have no adequate remedy at law.
And how are you going to do that?
Put forth your trust law, which would be the Bible and the Declaration of Independence. That's your law, the law that you stand on, and they can't see that on the public side.
All right. Well, what are we talking about here?
We're talking about our rights.
Rights. We're talking about rights.
So number 1 is lack of adequate remedy law. Number 2 is invoke our rights.
And since trust operates solely in equity, to enforce rights, you can't be at law, so therefore you can't have an adequate remedy at law because you're not even at law because trusts operate in equity solely. And then state the maxim, if there is no remedy at law, equity should act because equity is all about maxims. Now, how do you invoke a court of equity? What's the 3 things you're going to be invoking a court of equity with?
No remedy at law, protecting the rights.
I'm going to state the maxim that there is no remedy at law, equity should act. That's like stating a rule. So I'm going to present facts that this trust is private rights. Trust solely operates in equity, doesn't operate at law, and there's no way possible I can get a remedy at law because there's nothing at law that I'm claiming, because I'm not claiming any remedies at law. I'm only claiming a remedy, which is my right under equity.
So then what is meant when they say there's no remedy at law, and they go on and say unless by statute, because, I mean, it sounds like they're talking about colorable law.
Right, but now I don't put any statutes and codes in this pleading, because if I do, I'll be claiming an at-law remedy, won't I? So I can't put anything in there to reference any at-law side remedy.
So would you even use a
privilege give us, because we determined the other night that it's at-law is privileges that they grant to you that they can take away, and equity is rights granted to you by God, which never can be waived unless you voluntarily waive them.
And adding to that, would you not use the terminology bill of equity as opposed to a pleading?
Say again?
To add to that, would you not use a bill in equity, a bill of equity, as opposed to pleading?
Yes, I probably would. But let's say that that's the face of the pleading that they're talking about here. It says again, the touchstone for equity is the lack of an adequate legal remedy. To invoke the powers of the court of equity, it has been required that it affirmatively appear from the face of the pleadings or the bill in equity and from the evidence that plaintiff has no adequate remedy at law. That's it right there.
Can we write this out, or can we go slower to write it all down? Because that's really profound.
Say again? What was that?
Can you go slow so we can write this down? I think if we write it down, we're going to get it a lot better. If you go slow, I'll repeat it as we write it or something. But that was perfect the way you just said it, for me to understand anyways. I'm hoping everybody else understood also.
Well, everybody needs to go get Corpus Juris Secundum, a copy, because this is directly a quote right out of Section 18, the lack of remedy at law as ground and limit of jurisdiction. And I'm quoting, the touchstone for equity is the lack of an adequate legal remedy. The touchstone for equity is the lack of an adequate legal remedy. Continuing on, to invoke the powers of the court of equity, it has been required that it affirmatively appear from the face of the pleadings and from the evidence that plaintiff, or it could be defendant, has no adequate remedy at law.
Thank you. That was very good.
And then the maxim that I would use would be the maximum, if there is no remedy at law, equity should act. And that should be quoted in the pleading or the bill, because that's how you're going to invoke equity. Because this action to enforce where the villages was it was dismissed under the theory that the amended complaint was deficient because it did not allege facts demonstrating that the village had no adequate remedy at law.
Christian, it sounds like when you're reading this stuff, it's like you have to read it with a mirror.
Some of them I would read in the mirror, and some I might be able to take. It's kind of like you almost got to read enough of this stuff to get to the point where you can say, okay, I'm going to take that part, and I'll twist it this way to read for reflection.
Right.
But it's looked like most of this stuff is really written with both sides there at law and equity simultaneously, and you just have to cover up the at law parts that you don't want to get into and just read the equity parts.
So now my question is, it seems like they give us a choice. They give us a choice to go with debtor creditor.
Yeah, now what is the choice? What is that?
I'm sorry, what is the what?
That choice. What is that choice now?
Well, if you know what you're reading, there is no choice. You just take the equity.
Oh, well, you did make a choice, but what is that choice?
I don't understand your question.
The age of majority.
Okay.
And what's the age of majority?
Knowledge.
Power. What's the definition of power?
It's not force. It's the ability to use your, exercise your rights.
The power is the ability to choose or not to choose one over the other. That's power. So power is knowing when to choose what, which is age of majority. That's when you jump into power. That's when you've got the age of majority, when you've got the power. And what is equity?
Power.
Right. Right. Equity is all about rights. And God gave you rights on the Declaration of Independence. So now I can use the force of equity, because equity will be the force that will force them to not breach the trust or get them to correct a breach of trust, because it was my right that they do a particular duty or an obligation. And I'm not claiming any at-law remedies. Therefore, I don't have an adequate remedy at law, and my remedy is solely in equity. Now, how about this in ancillary cases? Anybody have any takes on that?
Are you saying that
ancillary and incidental jurisdiction? Let me read that again. Ancillary and incidental jurisdiction. It says, generally, a court of equity has jurisdiction of a suit ancillary to a suit, of which it has previously acquired jurisdiction, and such court has implied powers to do whatever is necessary to discharge the functions placed on it by law. How about we just discharge the function at law?
What do you mean by that?
Isn't that what we're doing by where we're not going into at law? We're just staying in equity because we're claiming a right? Aren't we discharging the at law side?
Yes, but also is that word in there implied. It says that I think the equity court can imply.
Yeah,
so
powers, implied powers, yeah.
Right, so it is implied. I thought that, or is it, when you say implied or implication, that is a term of art for construment, isn't that?
It could be, yeah, construing it, yeah. Because why? Because you didn't make a special deposit. You made a general deposit.
Exactly.
The general deposit would be made on the at-law side instead of a special deposit be made at the equity side, private side.
So which side is the ancillary? Is that, that's what I'm not clear on. Is the equity ancillary or is it superior?
Superior.
Oh, okay. So then what you're saying is the tone of the equity trickles down to the ancillary issue.
Yeah, they're trying to get you under general jurisdiction at law and give you a remedy from a privilege which is ancillary to your equitable claim if you stay on the equity side. And you can discharge the at-law side by not traversing into it.
Would that be done by the instrument of the court? Because it's implied that they're going to imply that.
Yeah, well, can an implied power also be a granted power, and where did they get the grant from?
Well, if we didn't make that claim, they would get it from our claim for our trust.
Aren't we usually the one granting them the at-law side by
Sure.
not knowing, because we aren't at the age of the majority, because we're not operating in power and really in knowledge of what the heck we're doing?
Yes.
Yes.
And it says generally, there's that word again. Generally, a court of equity has jurisdiction of a suit ancillary to a suit which was previously acquired jurisdiction. Sounds like you got in the at-law side first. But court of equity has jurisdiction, no? So of which has previously acquired jurisdiction, and such court has implied powers to do whatever is necessary to discharge the functions placed on it by law. I kind of read that to be discharges actually the functions on the at-law side.
So that means you're going to discharge or terminate them or render them nugatory.
You're kind of muffled. Say again?
You're going to discharge them, you terminate them, or you render them nugatory. I mean, if they become moot issues, is that what happens?
I kind of think so, yes, because it kind of like automatically discharges them because they have no grounds. There's no grounds on the at-law side. You're not claiming anything at-law.
Right.
What you got in there is rights that you're claiming under equity. Therefore,
Right.
the at-law side is discharged. Chris,
Christian?
go ahead. Unmuted.
Christian?
Yeah, Chris, go ahead.
Oh, this is Jacob. Chris?
Jacob?
Okay. When we're working on getting into equity, and we're doing so for a pleading of a past event. How do we get into equity if it's going to be a future harm and we want to ward off that harm?
Well, you have to have some kind of facts that something was going to happen, that there was irreparable harm coming into play next, which would be a breach of trust. And then equity would come in and force them, it would be a mandatory injunction placed upon them that they not breach the trust.
A mandatory injunction.
Mandatory injunction, that's a device used in equity to force somebody to do something.
So if they're going to go in and harm you in some way, take your home from you in a foreclosure or harm you in another fashion, then that would be the irreparable harm that's going to become you, and you wouldn't have to wait for someone to come after you to actually go get a remedy.
Yeah, the preliminary injunction would put a stay on everything and freeze it, where a mandatory injunction is more specific. It's going to identify a problem and compel you to do it.
So the preliminary injunction is general?
Yeah. It's an equitable.
General equitable?
Yeah, on the equitable side, it's more of a general nature.
Okay.
It's less specific. Mandatory injunction specific.
Okay, specific, less specific. Is there a time when we should discern that we should be less specific rather than more specific? Is there a pro and con on that?
Yeah, right, because you got to make all these choices.
So, I mean, was there going to be an instance as we go into a court of equity that we want to be generally specific in lieu of being especially specific?
Well, if I knew the exact problem, I'm going to just call a show cause hearing, and we do a show cause hearing as to why they should not be held in contempt, or a mandatory injunction should not be issued to prevent them from breaching the trust. Or maybe on a mortgage situation, I come in with a preliminary injunction just to freeze everything, because now I got two sides going on. I got an at-law side stuff going on, I got equity side going on in this, because at the mortgage foreclosure, as at law, but it starts out there and then it slides over into equity for the enforcement and the foreclosure, and then
so is that going to be two different cases? You come in on the admiralty, and maybe you come in on the common law side for the equity?
Well, a counterclaim could be considered two separate cases. But if we come in, if they hit you with an at-law foreclosure, that if you lose, they're going to go into equity and foreclose on you. But I come back in and come in with an ancillary case, which would be my counterclaim, and discharge this lower ancillary form, this mortgage foreclosure, due to something colorable, say unclean hands, and then have equity force them out of court.
Okay. On unclean hands.
Chris was in there. Let's get Chris in here.
Okay.
Chris, you're unmuted.
Hear me?
Yes, go ahead.
Oh. My question goes back to, we were talking about, let's see if I can go over my notes here. You were talking about, oh God, if I can go back over my notes here. I did have a point here, and it's been brewing for a while. Let me see if I can just put it out there and see if you can understand it. Okay, trust is one situation. You've got commercial law, which is on the government's situation. But in the meantime, you've got HCR 192, which is, oops, they made a mistake. They're caught with their pants down. They're going to be caught for treason, and we all know what the penalties for treason is. So it was my idea that if you're at law, you're saying that there is no remedy. So if there's no remedy, wouldn't it be a consideration that, oops, they got rid of our currency, therefore you have to go to equity for any true lawful remedy in lieu of their oops, their mistake?
Yeah, and force them to do the discharge of 192.
Yeah, and so this is the point that I've been, kind of like summating in the last 3 or 4 weeks, sitting there saying, well, there's a missing element in these documents, or at least in our understanding, is that we've got the backing of HCR 192. We don't have to go into statute, but what we need to do is devise a consideration of acceptance that would allow HCR 192 to slide us into equity and take us right out of at law. Am I on right track or what?
One problem I see is that if 192 is statutory, there's your at-law remedy right there, and then therefore you can't get into remedy in equity unless we can work our way around somehow.
Well, that's what we were talking about this morning, just the local people. And
ancillary here.
Huh?
That's what I'm bringing up, this ancillary here.
And my comment was, as feedback, is that we have devised language that basically names statutes without using the statute. That means we don't have to go into that type of jurisdiction or presumption that they may come up with. But because there is no currency and because there is no remedy, a person would have to naturally come to the assumption, or in maxims, which way you want to go here, that in order to be in a certain set of laws, that the elements and the requirements of that set of laws requires it to be under this set of elements. And if at law is missing the element of true lawful currency, therefore there is no remedy, just like what you've been trying to share with everybody this last couple of weeks, is that it's a no-brainer for a judge or anybody that's got any capacity of understanding of what we're talking about, is to move right into equity. Am I right or wrong on this?
Yeah, but I don't know. It's like you can't bring too much truth into the court, so you can't bring that in there that there's no money. They won't recognize that, and they won't lie to bring it in. Although you could bring that in under equity as evidence.
Well, could I add to that, guys? I mean, I think that's a good position. At the same time, recognize that the system operates on commerce. Whether there's lawful money or legal money doesn't appear to be the issue. But commerce has to go on, and I'm not sure that I think that position, they would consider that kind of esoteric, and I'm not sure that the esoteric positions are received very well by the court. So, especially saying, it's going to be, Christian says, it's too much truth. I'm just saying, looking at it from the economic standpoint, I'm not sure that would fly too well, because the bottom line is, at the moment, the courts are economic venues, and commerce is, and that always flies.
Well, the only exception to that, brother, is the fact that the UPU supersedes and is supposed to be the ground base for all of commerce and all communications around the planet, and anybody, including all countries that have signed on as a postal zone to the UPU, has to come under certain standards. Now, what they do within that province is their own business, with the exception that it interferes with the rest of commerce around the planet. So what I'm saying is that since IMF and you've got the U.S. Treasury and the Bankruptcy Act of 1933, that has to still play these, what do you want to call a clown act, where you're throwing all these different batons up in the air. They have to still manage some kind of a lawful system, of which leads me to believe that if you're at law within that system, it no longer applies once you hit the Bill of Exchange or the international level with trust. Therefore, trust exceeds. Right there is your argument. Well, I don't know. Maybe I'm just a cuckoo. I don't know. But what I'm saying is that there are so many different ways of looking at this, and that's just one of them, is that you can bring it to the UPU, and the UPU says, well, that's all you get within your postal zone, therefore you still have to act accordingly within the rest of the international level, of which has to be a lawful system. And I'm just throwing it out there for everybody to think about, because I don't know everything, but I do have certain capacity of understanding that at law is completely a cut less than what trust law is about, and what UPU law says too, and admiralty law, and all these different laws that supersede at law. And so therefore, just by looking at the differences of how they wager what it is to be within the country of the United States of America under the UPU zip code called United States of America, and all of the subsidiaries underneath that, is completely different than the rest of the world.
Okay, I'm not at odds with that. I'm just saying I think it's a very, I would call, esoteric position. And a more practical one would be, trying to do it, until we get more experience. I think that's kind of like an esoteric position. That's all.
Christian?
Yes, go ahead.
In Anglo-American law, equity derives from the historical jurisdiction of the medieval English Chancery Court. Equity in Roman and English law created a remedy in face of law's failure, and it worked to give relief from harsh application of legal rules in particular cases. Anglo-American law treated equity as a distinct source of law. Equity did not appear merely as a concept by which to interpret the law, but as a separate body of law with separate courts that had the potential to conflict with and complement the common law. When we do our pleadings, should we come in from the common law side to get into the court of equity?
No, common law is in trust. Common law is not equity.
But when we make a pleading in the public to come into the
common law is not at law any longer. Common law is in trust. Statutes and codes is at law. That's what's in force today.
Yeah, but didn't you say
law, you get into equity to get into common law?
Didn't you tell us before that common law is an extension of maxims of law, and equity law is an extension off of maximum law?
No, I think equity and common law are two separate things.
Oh, well, excuse me, because I believe what I have read and what I believe that I've heard in the past on these calls is that common law, maxims of law was an extension off of common law, and therefore maxims of law were the extensions into equity law.
When there was any discrepancy of common law or an equity, equity was to take precedence, and equity is based on maxims.
Okay.
Which is natural law, which comes out of Scripture.
Right.
All right. Well, then I stand to be corrected here. Okay. Good.
Your common law is held in trust with equity, and it's not accessible on the at-law side, except if you go privately. You get into common law.
That's why you have it in the trust res in regards to the Bible, then also the Declaration of Independence. So you can put that into evidence, or as trust res on the private side or the equity side in chambers, so the judge can see all this stuff.
But would you also say that common law would be the beneficiary to equity law?
No, there's deficiencies in common law, and equity takes up the deficiencies that was in common law.
Well, here it says that the Chancery Court was known as a court of conscience. It developed remedies and substantive law doctrines that differed from common law in numerous ways. The Chancellor exercised power over persons and could issue orders requiring a party to do or to refrain from doing certain specific acts. This authority grants...
Those are duties. Duties and obligations.
Okay. They said that this authority to grant injunctions was in marked contrast to the common law courts, which were largely confined to the award of monetary damages. The Chancery Court also fashioned the law of trust and enforced fiduciary obligations.
Now, if we don't have any money, how can we have common law?
Well, I agree with that.
I agree with
It's like they could nullify common law by taking out the money, but they couldn't nullify equity. Although they made a good attempt at it by hiding equity, by hiding it accessible in chambers.
It says that equity then was much more fluid. The discretion residing in judges drew much hostility from some of the American colonies. Chancery Court in the 17th century grew more involved with property matters, predictably became important.
Okay,
And,
Jacob?
hey, Christian, don't you think that the 13th Amendment that has been mysteriously taken out of ratification, doesn't that kind of apply to equity law in itself? I mean, it seems to be quite a match to me, but...
Well, that Constitution applies just towards fictions.
The 13th Amendment?
That whole Constitution is nothing but a subtrust off of the Declaration of Independence, applying to fictions.
So
Okay,
the nobility and the titles, everything that's
Fine.
mentioned in the...
I would say that Constitution is not mine. That Constitution is for the constitutors, those who swore an oath to uphold that Constitution.
So that's the same thing for the 13th Amendment he's asking about?
I think that whole thing is,
Okay.
it's ancillary to the Declaration of Independence.
You got to remember what common law is. Common law is a law developed by judges through decisions of courts and similar tribunals, also called case law, rather than through legislative statutes and executive order branch action. A common law system is a legal system that gives great precedential weight to common law on the principle that it is unfair to treat similar facts differently or different occasion. The body of precedent is called common law, and it binds future decisions. So common law is case law.
Well, here we also have that the introduction of equity into the American jurisprudence occurred during a period when equity was becoming rigid.
Hey, Jacob, you're breaking up. Can you get closer to your speaker or something like that?
Yeah, is that better?
I don't know. Can you repeat what you said, because I'm recording this?
Okay, I'll repeat. The introduction of equity into American jurisprudence occurred during a period when equity was becoming rigid. The discretion inherent in equity, with its authority bestowed on judges, was a subject of debate at the framing of the United States Constitution, and law and equity were generally merged. Christian, law and equity were generally merged through the Constitution.
Yeah, but that was before the Civil War and the 14th Amendment.
Yeah, but that's the description of equity. Now, when we go into equity court, we're bringing in our own law, and that's the law at equity that they have to abide by, not the description of equity that you're going by, Jacob.
Well, I'm just saying here under American law, they're looking at this, from a discretionary point of view.
Yeah, but whose discretion? From the privileged side that they're granting to us? And where they get their granting power from us? So who is the one that's really has the discretion here, except we've been duped?
And they're trying to turn it around on us, Christian.
Yeah, we're really the grantors creating this whole mess. We're allowing them to dupe us. We're allowing them to hang us and steal all our property and put it into whatever they're doing with it.
So do you feel, Christian, that the 13th Amendment would be an admittance of treason upon the American people, that they put that out there?
I don't think they could really make an accusation it's treason, because they really left you a remedy. But the trouble is they're blocking the remedy for whatever reason, whether it's we don't know exactly what moves to make to get around the roadblock, or whether or not they're just in there doing it every which way that we try. There's a remedy there available, but trouble is, are we being blocked by it? So we really can't say that it's treason, because if they didn't give us a remedy, then it would be treason. But now prove that.
Well, Christian, he or she who comes into equity must come with clean hands. So the two equitable defenses are the clean hands doctrine and latches, which I haven't heard you speak much about.
All right, but in order to make the claim, then what?
Well, when a person has engaged in improper conduct in a transaction and seeks equitable relief in respect to that transaction, a court applying this maxim will refuse relief.
But like little kids, all we come up with is conclusory pleadings saying, hey, he broke my arm. Where's your evidence? Where's your x-rays? Where's your sworn affidavits proving the facts? Where's your SOIs to support your claim? Remember, he who claims anything has to prove the claim. We're not good claim provers. We're good at complaining, just stating NOIs. We don't know how to do basic government, and that's what we're talking about here tonight. How to come up with a proper claim and do government so you can get a remedy. That's the whole tonight's topic. How do we get into a court of equity to get a remedy? We're excellent complainers. All we are is a bunch of sniveling, whimpering children. We're infants. Let's
well,
get
what
to
about
what about
the argument?
Operate power.
Oh, I'm sorry.
Let's just get into the age of majority so we can operate in power.
Okay, so how do we do that?
That's what we're talking about tonight.
Okay.
Well, doesn't that have a lot to do with just your own attitude and what your own intent for your own life is? Because you can take a bum off the street and his intent is to have, like, his weekly drugs or alcohol. But then you take another person that won't put up with anybody's shit, and his intent is to actually have power that actually dictates either good or bad on the planet. There's two different people, two different intents. One of them actually influences, well, actually both of them influences, but when it comes down to it,
we've allowed the system to be morphed into something and changed it. We've allowed it to be changed by them and how they've molded it.
Yeah.
It's like we have to run through this at-law side to get into the equitable side so we can get this remedy. And they're the gatekeepers on this. You know, until we change the system, figure out a way to change the system, that's the system we're stuck with.
Or you work within the existing system. You know a man by his works, how he acts, how he presents himself. Okay, what is his law that he has presented to the court, and he abides by that. And once they see that we are standing by the law, that we proclaim that is ours, then they will see that we are come of age, and they'll leave us alone.
Well, when you become of age, you have detached yourself from all their traps. That's when you become of age, of majority, where you can have standing. But when you go into equity, Christian, I mean, that whole morality thing isn't going to hold up compared to having our records in order.
Yeah, but Jacob, just stop and think about it. You remember all the stuff we've been working up with the debtor creditor stuff, of where if you show yourself with your activities that you're the true creditor based off of the secure party documents and whatnot, that by your activities thereof, that the government will take acknowledgement of you and your activities, that you're acting in the capacity of a true creditor. Therefore, you do get that 14 year of age of majority, of where you're initiated into their group, with the consideration that Christian's been saying is don't hold them in harm's way because of the things they kept from you for all those years, is that you should just accept the facts that you're initiated or brought into that group. Therefore, you can have easy access under those conditions. The initiation is not easy, but the people do make it into it are living in gravy for the rest of their lives.
Yeah,
Christian,
so how do we get into a court of equity?
Yeah.
Court of equity.
I mean, how much is our behavior going to have to do with getting into a court of equity, Christian?
Our behavior?
Yeah.
I don't think it's.
You have to comport this to something that they can see, and they are only looking for a manifested record, which demonstrates
Right.
your.
A manifested record.
That's how that's how they manipulate you, because that doesn't require assent to your knowledge.
It's the
But now,
documents.
when I understand that what's going on, and I have sent here, then I can manifest any records that I want.
Yep. That goes a little bit like with what Patrick Devine's been saying is that if you set precedents in your activities engaged with the government as they take acknowledgement of your activities, therefore they're informed or noticed or whatever, NOI or whatever, they are given proper notification that you're on your upswing and that you're to be acknowledged and respected thereof.
That's what I was trying to bring out in that that 1794 document that I was reading.
Yeah, I read that.
The Director of the United States in April 22nd, 1794, where it was resolved that there was this lost note. And what they did was they did a advertisement in a paper where they did a show cause why any new certificate should not be issued to him or her in lieu of the lost or destroyed one. And they ran that for 6 weeks. And really, all that was a declaration. And when there was nobody that answered that, then it stood good. It was already done. That's how they did government back then. That's how they're doing government now, I believe, except nobody's doing it. We've kind of abandoned the republic because we've lost the knowledge of how to go about doing these things.
Can we use that tactic in a mortgage when they on a post foreclosure?
Well, yes, we're making a declaration. Remember, a declaration is one method of formation of a trust. And all we got to do is just notify these people, merge the titles, and extinguish the debt. And then give them something colorable on a simultaneous line on the public side, the at-law side. They'll give them reason to save face, say like unclean hands. It's like we've got this ancillary case, 2 cases, and they're coming in on the at-law side for a mortgage foreclosure, but yet you're going to come in on the equity side and claim trust as your counterclaim. And that's going to extinguish the lower form, the at-law side, because really what you're doing, there's a trust here, really. There's 2 sides. There's the public side of the court. There's the private side of the court. That's a trust. That's segregation. They have segregated the court. They have formed a trust in the court. And all I got to do is merge the titles. And I take the lower contract, debtor-creditor contract, merge it in the higher security, and it's extinguished. The lower is extinguished in the higher. That's merger. Same thing we're doing here, trying to get into equity. That's what we're talking about. We're trying to merge and extinguish the at-law side.
Hey, Christian?
Yeah, Shane, go ahead.
The person is what operates in the law, right?
A person is what now?
Well, the person operates in the fictional statutory law realm, jurisdiction.
All right. In commerce,
Would
yeah.
you say, okay, and the man is what operates in the private, in
Right.
chambers and so on? Okay. So I've heard Winston say, you can walk in there and say something like, do you realize you're harming a real man? And he says that they have to help you out. And I was wondering if he's making reference to something like that, and if that could not be a possible way to get into equity.
No, I know too many people have kind of tried that before, and that didn't work in the past too good. And then I got all kinds of problems. They just walked all over that and continued on.
Is it maybe because they just didn't do it the right way, though?
Yeah, it's like they can't see the real man in court at law side anyway. Can't even make that claim. You just waived that part.
Mm.
I'm thinking, you know, we're trying to read too much into this stuff. It's a lot simpler than what it looks, what it seems. I'm trying to reduce it down to the bare minimum of what we need to come in, just so it looks colorably on the public side, but yet we're directing, ordering, decreeing on the private side. Here we had all the power all along. We had all the force all along. Just like Dorothy wearing the shoes all through the movie. All she had to do is realize and believe that she had to click her heels 3 times together and she's back in Kansas.
Have you ever heard, I don't know if it's true or not, never had it confirmed, but somebody was saying there was a case where somebody said, well, we actually had something in Canada. But anyways, the first guy was that Sidney Michaels. He's a Texas guy, but he said something about somebody said that they pled the blood of Christ, which of course I didn't completely understand, but I'm thinking there might be application. But we had a recent, not recent, but a while back, a case of some lady, I forget what she was, in Alberta, and I think she recited the Lord's Prayer or something like that. And again, I think they said that they took the whole case was shut down because of that. And of course, Dalton and Gwynny are
different laws up there than we have down here, because I know of a fellow for a fact, he came in and pled for forgiveness, but really, forgiveness is for the real man.
Well,
if the real man can't court, then forgiveness was not meant for fictions. He ended up getting railroaded for pleading that.
But in both of these cases, they're making a specific biblical reference. One was the Lord's Prayer, and the other was the blood of Christ.
Well, look, at the at-law side, there's no Bible in the court. There's no God in there.
What would they do, though? Refute that?
Well, they just ignored it and went right over it.
Well, in the case of this lady, she didn't. And it was such a big deal that our premier came back and said that he was going to see if he could get the Lord's Prayer removed from, I forget, one of our constitutions or one of our legal things. And I'm wondering if that was just a big song and dance.
I don't know. That was in Canada?
Yeah. There was some case. I mean, I guess I'd have to find it and pull it up, but that was the big deal. And,
It's okay. You could get that to fly up there, but I think down here, that's been tried before. That doesn't work.
Hey, Christian?
We have totally ungodly court today.
Christian? I found a section that should be read here. Can I just have 1 minute, and I'll read it off?
Go ahead.
Its exclusive jurisdiction is also extensively exercised in granting special relief beyond the reach of common law. It will grant injunctions to prevent waste or irreparable injuries, or to secure a settled right, or to prevent vexation litigation, or to compel the restitution of title deeds. It will appoint receivers of property where it is a danger of misapplications, in its will compel the surrender of security improperly obtained. It will prohibit a party from leaving the country in order to avoid a suit. It will restrain any undue exercise of a legal right against conscience and equity. It will decree a specific performance of contract respecting real estate. It will, in many cases, supply the imperfect execution of instruments and reform, and alter the according to the real intention of the parties. it will grant relief in cases of lost deeds or securities in all cases in which the inference is asked. Its general rule is that he who asks equity must do equity. If a party therefore should ask to have a bond or a usurious debt given up, equity should not decree it unless it could be bring into a court of money honestly due without usury. I'm going to put that over there on the site for everybody to look at. This is only one paragraph to a very, very nice Chancery Court of Equity definition.
Okay.
Put that up there for everybody.
Christian?
Yeah, go ahead.
I would like to, declare our maxims for getting into the Court of Equity and have you address this. But they would be the foundations of equity would be he who seeks equity must do equity. He who comes into equity must come with clean hands. Equity follows the law. Equity acts specifically. Equity regards substance rather than form. If we take the specifically as in special, the maxim means that a party who sues in equity can recover the precise thing that he seeks rather than monetary damages as a substitute for it. This maxim is the remedy of specific performance. Do you know anything about that specific performance?
Yeah, that's breach of trust.
Okay.
You have to specifically perform according to the duty or obligation that you were supposed to uphold and do in the trust.
Well, but I guess last night I was asking about the negotiable versus non-negotiable remedy portion of ordering the proceeds, back. And in a mortgage situation where...
Give me my special back. That was the duty. Equity is going to force you to give me my special deposit back. Give me my note back.
Yeah, but what about the monetary damages for misusing it?
That's not equity.
Well,
that's bad law.
And you let that part go then?
Else come in and with that later on.
Well, that's a separate ordeal?
Yes. That's an at-law remedy.
Ah, okay.
Go in with that with damages because you will nullify your equity because you will get compensation at law and now you've got an adequate remedy at law. And you can't get equity.
I get it. I see now. Okay. So can you get your remedy for a precise thing as opposed to monetary damages, and then after you've gotten that,
what? Damages is what?
Damages is negotiable, whatever.
Yeah, it's a value.
Yeah, it's a negotiable thing.
That's at law.
Yes.
What's in equity?
Yeah, but my point is
the thing, the res.
Right, it's a thing. Yes.
What's its value? It doesn't have one.
But if you go into...
It doesn't have a value. So therefore you can't get damages in equity. You're going to get your thing back.
You're going to get your special deposit back?
Yes. Equity is going to force them to give you your note back.
What if they don't have it?
Well, now you can come at law and you can get it for damages because you just won under equity.
That's right, because I was reading something about certificate of security today, and if they have lost or have damaged that, it's a very, very hard task for them to get a certificate issued out of the Federal Reserve and or the Security Exchange Commission for a certificate to issue back onto them if they've lost that original note. It's extremely hard. So therefore, you're almost guaranteed, almost 90 or better percent, that they're never ever going to be able to have a certificate that backs that you're talking about, Jacob.
Like once you win in equity, you're guaranteed to win damages at law.
And that doesn't waive your position?
No, because you didn't go clockwise, you went counterclockwise.
Oh, I see. Okay, counterclockwise. Got it.
You came into equity first, proved your case, won in equity, and now they can't give you your note back because they don't have it or it was destroyed or whatever. Now how are you going to get a remedy? Well, now we go at law and we get damages.
Here's another quote. This is like out of a 100-year-old manual. It says, Bill of Equity filed in the United States Supreme Court, but this relief will be given only when evil is of serious magnitude and leaves untouched the lesser nuisance against which a complete legal system will enable a state to protect itself. To attain a proficiency, which is possible in the statutes defining criminal nuisance, a clause should be introduced which will clearly include the effects within the state of an act performed by another state. Then it goes into equity jurisdiction and enjoin criminal proceedings. As a general rule of court of equity will not exercise jurisdiction by way of injunctions to stay proceedings in a criminal matter or in any case not strictly of a civil nature. That goes into subtitles. In most jurisdictions, however, there are well-organized exceptions to this rule, where a court of equity has jurisdiction first, and one of the litigants tries to defeat that jurisdiction by starting a criminal prosecution involving the same parties on account of the same subject matter, the criminal proceedings may be enjoined, but the parties and questions involved must be identical. The probability, the most frequent exercise of equity jurisdiction in relations to criminal proceeding is stay prosecution under an invalid statute ordinance, where the complainant's property rights are affected. And then it goes on into the next page, which I don't have access to.
I'd like to point out that when they say enjoin, that enjoin means that they're stopped, they're stayed. It doesn't mean to join them in.
Good. That's a good. I was wondering about that.
Join means to stay or stop them from the action.
And that would be under, it looks like a law, the Yale Law Journal. That would be under justifying a court of equity jurisdiction.
Yeah, equity is an enjoining action or a stoppage action. It's a preliminary injunction or a temporary restraining order. It stays. So here's one under Section 13. Under the trivial matters and jurisdictional amounts, it says under the exceptions to the rule, it says that in a suit to reform a conveyance, the value of land omitted by mistake therefrom, while an element in determining whether or not equity will take jurisdiction, is by no means a controlling and determinative consideration. The omitted land may be of great importance to the value of plaintiff's remaining land, or it may have a particular value, pretentium affectionis, in plaintiff's eyes. In other words, the value is determined by you. And the next section, 14, uselessness or impractical relief. And here's where I had a bingo that I said the other night, where a court of equity will not do or require the doing of a vain or useless thing. It will not use its powers to accomplish a useless purpose, nor will it grant a decree which does not confer a benefit, which is impractical as concerns enforcement, which is not enforceable, or which is ineffectual because compliance is impossible. So the court of equity will not do a useless or vain thing and will not require the doing of a vain or useless thing or in the performance of an impossible act. And accordingly, even though the court has jurisdiction, it will not lend its powers to accomplish useless purposes, nor will it grant to a decree which does not confer any real benefit or effect any real relief, which is impractical to carry out, which is not enforceable, or which is nugatory or ineffectual because compliance within it is impossible. Here we go. Courts also refuse to grant equitable relief where, if granted, one of the parties may nullify the action so taken by the exercise of a discretionary right which either the law or his contract has conferred upon him. And nullify the action so taken, that would be, but you have to make the claim or you're going to waive that. Yeah. Now let's say that action so taken, let's say unclean hands. So to grant the equitable relief, that's foreclosure. So the courts are also refused to grant equitable relief, say foreclosure, where if granted, one of the parties may nullify the action so taken by the exercise of a discretionary right, say by trust, which either the law or his contract has conferred on him. Doctrine of unclean hands will nullify the action, the foreclosure action.
Well, that was before the unclean hands doctrine came out, so that would be more of a breach of trust or a contract right there, wouldn't it?
Well, unclean hands is equitable relief.
Yeah, but that document that you're reading off was prior to the unclean hands doctrine, if I'm not mistaken.
Let's talk about court of equity here.
Yeah, well, I'm almost, I could be wrong, but, you know, I read that one before, and it was, doesn't matter.
So this was before the unclean hands doctrine, you say?
Yeah, if I'm not mistaken, that was an older case before. That meant that it would have probably more applied towards somebody being a breach of contract and or trust.
Yeah, well, I was just thinking that the grant the equitable relief, that's foreclosure, because foreclosure is in equity. But if granted, one of the parties may nullify the action so taken, and how would they do that? Say by unclean hands doctrine.
At this point, yes, I do agree.
I'm looking for the statutes where here was getting back on that conversation we had a little bit earlier about the influence by statutes.
Well, isn't the unclean hand doctrine, isn't that a statute by itself? Pretty sure it is.
Yeah, I think that's why I say that one is both a colorable at-law side and also an equitable. So it's kind of like a portal one on each side. That's colorable is something that they could recognize because that's statutory, yeah. But it's also equitable.
Actually, 18 U.S.C. 25.
Was that
Oh, look
18?
at that. Hey, Christian, check this out. That was actually part of the package for the U.S. Patriot Act. Did you know that?
What was that again?
The unclean hands doctrine was part of the package for the Patriot Act.
It was?
Yeah. That was the first time okay, so it was, let's see, unclean hands doctrine. Okay, so that was the Sherman's Act. That was 1890. It was included under 18 U.S.C. 2515 for anybody that wants to go back and look at the Patriot Act.
If anybody wants to ask a question, you have to press *6 and *1 to get in the queue. Anybody
Christian, can I read something while you're looking?
Yeah, go ahead.
Well, I'm still on. Well, one thing is that, you know, to get into the court of equity, we have the maxims of equity, we have unclean hands, but we have laches and estoppel also, do we not?
Yeah, that's equitable also, yeah.
So under laches, laches is an unreasonable delay by a person possessing a legal right in enforcing that legal right that produces prejudice to the person against whom the legal right is being enforced. If we are not at the age of majority and we are as a child a ward, then they're going to be looking to us as they're lording over the legal rights they have over us.
Right.
But in order for us to rise above the age of majority, we would have to declare our inalienable rights.
I don't know if it's inalienable rights, but it's coming to the realization that you can make a choice. Because under the corpus juris, reading under the Gordian ward, that it didn't have to do with the age of the clock, but it was the fact that you came to the realization that you could make a demand for a final accounting in settlement, and that terminated the guardian ward relationship, and that was really the age of majority.
And how are we to declare and or express or behave or imply that area?
Well, we're going to have to know a whole lot more than I think we really know in order to be able to administer this trust without breaching it ourselves or giving it away again. You know, we can probably get it, but if we get it, can we hang on to it? Just like what Franklin said when he was asked, Mr. Franklin, what have you given us? I've given you a republic if you can keep it. So we've got to trust if we can keep it.
So with respect to being on an unbalanced scale, tilting one way to the legal rights and the other way to our age of majority being expressed that we're going to ask for an accounting of the proceeds from us coming to the age of majority, how do we relate that to going into a court of equity?
Because it's coming of age and knowing how to go into a court of equity by knowing the tricks and traps that are actually functioning as the key that locks the door. And we discovered the key, and now we can open the door.
I mean, because I see that as being the biggest problem, where the judge is going to try to, you know, lord over the legal rights being an issue, as opposed to our having standing with proof that we've come to the age of majority, and we would have to have some kind of declaration for those proceeds to have been ordered to be given unto us, and who would we do that with?
Okay, in the movie The Matrix, at the train station, when Neo was on the steps there and he stopped, and Trinity asked, what's he doing? And Morpheus said he's beginning to believe, and he fought the agent. You know, he lost that battle. But at the end of the movie, after he got shot and he came back to life, and he found out he wasn't dead, when the bullets started coming at him, what did he say? No. I think that's just as simple as that.
He said what?
He said no. And the bullet stopped in midair. He held his hand up. He said no. The bullet stopped in midair. It's as simple as that, I believe. I don't have to listen to these courts and these judges. I just have to know what to tell them. And I just basically say, no. I don't grant that. I don't grant that.
Oh, right on the spot there?
On the spot. No, I don't grant that.
Well, I can verify what you're saying, Christian, because in the misdemeanor case of where they were trying to entrap me and they found me guilty of practicing being a contractor when I was just a handyman, they entrapped me. The judge at the end of the jury trial, they found me guilty. He asked me, he says, you got anything to say? And I says, yes, I don't give consent for any punishment in regards to any of these considerations or judgments that you have found against me. And he hit the gavel, and the case was over.
So when we establish our standing by expressing a trust and doing the general deposit withdrawal and redeposit under trust, in effect, we've changed the guardian-ward relationship all simultaneously, and we've broken the suretyship. Now we can come in the power and use the force and say no.
I agree.
That's really profound, Christopher. Wow.
Yeah, you bet. I could not believe it from my own ears. The judge didn't know what else to do. He hit the gavel and says, case dismissed. That was it. I mean, after 3.5 years of learning law from 2001 to 2004, I fought and defended and learned everything I needed to know up to that point. And the last thing that I had as a resort at being found guilty by a jury at the sentencing, he asked me, do you have anything to say? And I says, yes. I do not accept, I do not consent to any of the judgments and or the sentencing. And he says, case dismissed. That quick.
Wow. That's a really powerful testimony. Great job.
Well, that's what Christian's trying to share with everybody is that the power of no means is that you are who you are without the name. And when you say no, that means there's no question about what the words N-O means.
So when I establish my authority, now I'm not under that guardian-ward relationship, and I've got the authority to say no.
What part of no do you not understand?
All right, this is under section number 5 of the Guardian and Ward. It says guardians under civil law. In the civil law, a guardian is termed a tutor, whereas guardianship relates to a person or the person in the estate, and a curator, whereas guardianship relates merely to the estate. So today, the laws are the tutor that are leading you towards getting you out of infancy. because they're putting you between a rock and a hard spot, and they're disciplining you. And it's making you wake up. When they take your property, when they foreclose on you, when they throw you in jail, you should be starting to wake up.
Hey, Christian, here's a good quote that right in on the Guardian stuff. The bank may make payments of funds directly to the minor without regards to his or her minority. Unless a guardian or parent is an account owner, the guardian or parent shall not have any right to access that account. The bank has no duty to inquire of the use or purpose of any transactions by the minor or any account holders. The bank shall not change the account status when the minor reaches age of majority, unless he authorizes in writing by the account owner. Now, doesn't that sound a little bit like the relationship of a person to the United States Treasury with your birth certificate and Social Security number?
Yeah, yeah.
So everything that the court systems and all of these debt collectors outside of being a true creditor of the IMF and or the U.S. Treasury are all prostituting and doing bank ID theft on your name and your signature, and that statement I just read off is proof in the pudding right there.
Well, if we stop handing them that, then they wouldn't have that implied power.
That's why that's why I totally believe in where you're moving with this is that in order to get your rights back, we have to be within a set of laws that they can't abridge. So far, with at law, they can abridge that, just like what you said. There is no remedies there because they own that lock, stock, and barrel.
Yeah, right. You're dancing to their tune on their stage, using their tools, and you expect to get a remedy? You got to have your head examined.
That should be part of our quote with where we feel as a grantor and the settlor that there is no remedy at law. By affidavit or declaration, we need to have that as part of our documents that shows that we don't believe in these sets of laws. We don't feel that we should be subject to them because we never gave consent. This is not our intent to live on this planet. I mean, that kind of language that we put in any of our documents that we put on public record is going to stand when it comes time for us to have to go into equity. It shows that we had no intent to participate with these sets of presumptions.
Yeah, but we should be given notices so that we can still protect those substantive rights because we can't make those claims in the public.
Yeah, whatever way we're going to do it. I mean, I'm not clear about everything, but I'm clear about some things. But one of the things is the what needs to be kept on the private as opposed to the public. If I was to go out there and tell a judge straight out that, you don't have no jurisdiction over me, I don't know how to discern the difference between what's important. Should I be saying that on the private or the public? I would just tell the man, look, you're a man, I'm a man. And, if you were Chinese, I'd sit there and laugh at you when you were telling me that you were going to arrest me. Anybody outside of anybody that sits there and acts as an authority in this country that sits there and say that they have authorization over me, you have to question that. Because outside of being married to another person or you're in a relationship to an organization that you have duties and obligations, I think a person should be absolutely free of anybody else's infringements or abrogations against you.
Yeah, that's why I want to go in and terminate the straw man so there's no idem sonum's connection in any way possible, shape, or form that I'm the surety for that sounding alike name, because that sounding alike name, straw man name, is terminated.
Christian?
Yeah, Jacob, go ahead.
In reference to what you just read about the curator, the curators are often confounded with tutors, but they differ in many respects. Tutors are appointed principally for the guardianship of persons and only secondarily for the care of property.
Right.
While
For the estate.
hmm?
The curator was for the estate.
Right, the curators are, let's see here. Yeah, it's for the property, you mean, the estate.
The estate, right, the property.
Okay. And,
Being status, because what kind of status are you keeping your tenure or your estate in?
yeah, but I think my point was that, you know, when you become of the age of majority, you know, it says that the tutor may become the curator until the ward is 25 years of age, but he cannot be compelled to undertake such a charge. The curators, according to law, are to be constituted for those who are, you know, not able to do for themselves, mentally weak, addicted, gambling, whatever. But the administration of the property cannot, however, be taken from a person merely because he lives, whatever, luxuriously. Curators may also be appointed for captives, for the absent, the deaf, or the dumb. Before the curator enters the administration of property, he is obliged to give proper bond for his fidelity. Now, what does that mean?
Well, he's got to stand good for his duties. If he breaches them, then you go after the bond.
So when we reach the age of maturity,
though, that's at law.
so when one reaches the age of majority as a ward, and they are now being handed over to the curator, is there another step that we can see? You know, the coming of the age of majority, and then we also face the curator at that point?
Well, here's the thing I was trying to point out on the 5-8 show. All these agencies are nothing but general deposits. How do you change a general deposit's nature into a special deposit? Doesn't make any difference about the agency type. It's all general. And I can do any general termination and change its nature in one snap of the fingers. How do you do that?
Well, you withdraw from the one relationship and you create the new relationship.
There you go. Withdraw and redeposit. Withdraw the general deposit, which would be all the agency colorable leaves on the tree, and you get rid of them all at once by pulling it out of general deposit and resubmitting it as a special deposit. Bingo. Got them all. Don't have to worry about all of them. All of them in there is confusing if I look at them all individually. Let's get them all in one bag and do the whole bag all at once. Put all the leaves in one bag. I don't care what kind of agency you got. Got this leaf agency, that leaf agency, this leaf agency. Look at all those leaves. Oh, man, that's too much to handle. No, let's just pick them all up, put them all in a bag, get rid of them all at once. Do a withdrawal and a redeposit and a special deposit. Bingo, they're all gone. Anybody? Comment?
Well, there's obviously a relationship between the Court of Chancery, the guardianship, the ward relationship, the authority that they're trying to exercise over us, and the stronghold that we have to break by declaring our standing.
Yeah, but how do I do that? I'm declaring my standing and declaring my age of majority by being able to discern or use the power, make a choice to withdraw this general deposit of all these agencies and their power, disconnecting it, which is merging the titles and extinguishing that agency, and redepositing it as a merged and under special deposit, under trust.
And that's the reasons why I was mentioning to everybody before is that that's how important it is to get, Christian, I'm working on getting the confirmation out of the Securities Act and the National Banking Act. We have found the information that says that there's only 3 creditors that are bona fide certified creditors. That is the signer, which is the living man, the U.S. Treasury, and the IMF. The rest of them are debt collectors. That is part of the strategy.
They're all agencies, right?
Yeah, that's the strategy of the majority. You are part of the majority. The rest of them are debt collectors. They're a minority to you. And this is the language I see that we need to add to our arsenal here. So as soon as I get that information, I want to pass that to everybody so we have at least how the U.S. Treasury and how ACR 192 and Public Law 73 actually saw the living man in lieu of the Bankruptcy Act, which would have been treason if they didn't have a remedy for the people. And so therefore, this is what makes us a creditor, is that they apologize forever until they get us out of bankruptcy. This is the catch-22 that they can't get away from, and you've got them every time on this one consideration. And all we need to do is come up with the language that would facilitate us owning that age of majority by claiming that.
Yeah, under trust.
Yeah, exactly, under trust, because basically the bankruptcy is a trust. Can't get away from that either.
Or else they'd be in breach of trust. But nobody's enforcing it under breach of trust. That's the problem. Because they haven't declared it to be a trust. And there is no trust until you declare it as a trust. And then
but if you read my documents of how I go about doing business with the banks, you would see that the first thing I name is that the cause of actions is that you're in breach of trust and you're in breach of public trust, and I name it right out, HCR 192 under 14 and 91 of where...
Well, I don't want to name any statutes. I just want to come under breach of trust because that's equitable. If I put any other at-law stuff in there, there's where my remedy comes in, and I negate the equity.
Yeah, I know, but when I was mentioning that is that when I do my plan of attacks against the banks on the debtor creditor side, I've got it all laid out, and it really nails them that they are defrauding the United States of America, and there is no other question about it. If you were to walk into a court on the debtor creditor side, there's your answer right there. I know that you don't want to deal with that on these calls, but I got that one nailed down pretty good. Nail them every time for that one, defrauding the United States of America.
Okay, another question? Anybody comment? JC, you on tonight? Eric, you back? Press star 6, get in the queue. Star 1. You're unmuted. 561, you want to make a comment, question?
Oh, all right, Christian. Fritz, Florida. Yeah,
hey,
they're in, hi, good to hear you. They're in breach of trust by their oath already when they've accepted the bankruptcy. They took an oath not to accept anything but gold or silver. And then you got the IRS, which is trust number 62, the Philippines, which is trust number 2, and where's all these other trusts that are all there in between the other 60 that we don't even haven't identified yet?
I don't know. I haven't found them all. There's too many of them.
But we've also got an equitable right to set off.
Yeah, yeah.
And there's also equitable tolling, which states a doctrine that the statute of limitations will not bar a claim if the plaintiff or defendant, despite diligent efforts, did not discover the injury until after the limitations period had expired. There's also another one called latent equity, where an equitable claim or right known only by the parties for and against whom it exists or has been concealed from one who is interested in the subject matter. So that's not exactly full disclosure, and that's another breach of fiduciary duty when they're in the in public policy or public trust. So that takes them straight into the private, and they need to do that final accounting.
Yeah, give me the account. Do the final accounting, give me the account, terminate the relationship.
Exactly.
Christian, what about the clause in 1491 that says that the United States of America put an automatic lien against all properties, therefore they are foreclosed and mortgaged back to the people in lieu of the Bankruptcy Act that they instilled in 1933? And if that's not a breach of trust to allow a bank, a debt collector, is to put a lien against a lien, and I just don't understand why people are not catching on to that one little morsel that would alleviate all foreclosures completely by defrauding the United States of America with a lien that's already been placed by the American government that supersedes any other lien that the mortgage companies can ever put on property.
Well, what was that, 1942 or 41?
No, the Bankruptcy Act of 1933 gave you Public Law 7310. And
right.
In that act, under Section 1491, the congressional instatement was that for dollar, every dollar would be obliged and paid by the United States Treasury, and that included a lien in that 1491 against all properties, which made every property across the United States of America under a mortgage lien by the United States government in lieu of the bankruptcy. And that means that they are superseding any other lien, including all other mortgage companies. That means that they're defrauding the United States of America by not reporting to the United States of America that they have got a foreclosure process on a piece of property that actually belongs to the United States government in the end product.
Well, it's kind of like the Carlos was talking about. As soon as he puts his property into an individual's trust and they start coming at him, once he notifies them that, hey, this is in trust, they turn around and walk the other way. But in that respect, when have we done that with them?
But which one, the U.S. or the banks?
Well, on just exactly what you're talking about. When did we notify them that this was in trust? Because if we would have, their lien, they would have turned around and walked the other way. We've never expressed it to be a trust.
Do you think we can incorporate that kind of language, or is that too statutory for us to do it into a trust?
No, like it says, it's the statutes and codes are a public trust, but we've never declared them to be a public trust. If we would have, then their lien would be ineffective because they'd have to turn around and walk the other way.
Well, that's really true because, you know, the Hidalgo, or what do they call it, the Guadalupe-Hidalgo Treaty out here in California, it stipulates that all pre-existing Spanish land rights and patents will not be succumbed by the United States occupying or enjoining the state of California. So therefore, in the Quintaro Treaty, which was a part that the Spanish government was adamant about having as a amendment to the Guadalupe Hidalgo Treaty, is that they were not to use any of the Spanish land patented lands, of which almost 90% of all the the state of California was all Spanish land patent. That means that no government offices can be occupied on any of these land patents. And if you really want to call the numbers on them, every one of these civic centers and all these government officials and whatnot occupying all these land patents, the Spanish land patents, need to be taken off these properties. And on top of it, they cannot do any lapses such as property taxes on the properties. So what they're doing is they're in gross negligence to the treaties that are already instilled.
Yeah, but we haven't expressed a trust, and but if we would have, then the liens would be ineffective against the assets being held in trust.
Would you consider a land patent a trust?
I think a land patent is just connecting on the last buyer on a chain that represents an unbroken chain to go back to where the property first originated.
How would you do? How would you instill like a land patent into a modern day trust of your considerations of your own property and whatnot? How would you do that?
Purge the titles, terminate the trust, and bring the land patent forward, because the land patent can't be brought forward because it's being held in suppression, so to speak, because of the trust.
Yeah, I agree. You're right on the money on that one.
Christian?
Yeah, go ahead.
I've just been thinking about, this area, because it seems like the two most important things that we need to get into the court of equity from the beginning of our conversation is, number one, the lack of an adequate remedy at law, and the other one has to do with our rights. And talking about the guardianship and the ward and what have you, and the tutor and the curator, we're talking about us as individual men or women, whoever on the call. But there's something that I think we're missing. There's got to be something that has to do with family, and so it has to be like where, as an example, it states here that a father's right to appoint a testamentary guardian for his son was conferred by an English statute of the year of 1660. In England, the Lord Chancellor presided in the Court of Chancery was the paramount guardian to all the infants in the nation. The sovereign, as parents perenne, was deemed to be the protector of the interests of all his subjects who were minors, and the exercise of this universal guardianship devolved upon the Court of Chancery by what was assumed to be delegation of the royal authority. So we know in 1921 they started to bring in this parent patrines thing, and that's when they ushered in this registration of the birth certificates off that concept. And so I think that this goes deeper into the marriage bond. Well, I think when they have a marriage certificate, they're actually bonding and turning the marriage certificate into a security like they are the promissory note in the mortgage relationship.
Yeah, everything's commerce on public. Everything's commerce.
Right.
Everything is a certificate that's being traded, and your signature empowers it.
Right. So when the couple gives up this other form of family paramount guardianship, and the marriage certificate now is bonding the woman to the man, which I'm sure doesn't go over well with MI6 and their feminism routine. So you have the law administered in the court of the chancery is the basis of the law of guardianship, and any court possessing chancery powers possesses a controlling and superintending power over all guardians. So it looks like they're trying to bond the nation and its family under this paramount guardianship. You see any relation to this at all?
Yeah, but then again, it's another one of those leaves in agency that I can put in all in a bag and get rid of the whole bag all at once.
Yeah,
I don't care what age comes
here
to me.
They start trying, but they move this whole thing from guardianship to this paramount guardianship to the parent pareens, to the children, to the education.
I don't care what relationship you can dig up. It's all the same thing. It can be gotten rid of by a withdrawal and a redeposit.
Okay, so let's say the family is this. The family has a set of birth certificates for the children and the father and mother. They also have a marriage certificate. These are all general deposits, are they not?
Right.
Okay, so if you're going to reverse what they've done to these parties, then you would have to withdraw from each one of these relationships to where you're going to be able to be in a position to ask for, to become your age of majority.
Yeah, but
you're not getting where we're doing it at. That's probably what you're not seeing.
You're not getting one factor is that anytime that you show that there's an act that you do, there has to also be a remedy of where you're moving your party to. In other words, if you're saying that I'm going to move it out of general depository, then they're going to question whether or not you know what you're doing. Do you know where you're going to be moving that? By special deposit, by putting it into a special account, shows that you know exactly what you're doing, because I've been through this before on different issues completely different than what we're doing with law, of where you can move a person out of one situation, but they always reverse back to it unless they have intent to go to the other place.
Let's say all these different agencies, however many there are, that each one of us might not have the same number, but whatever it is, let's say there's 50 agencies. Let's say there's 500 agencies. Let's say there's 5,000 agencies. Let's say there's 50,000 agencies. I don't really care. Where are all the agencies at?
They're all in fiction.
Right, but where are they all kept? In the IRS/Treasury, in the IMF master file.
They have to keep records of.
They're all commerce governed, and they're all keeping track of them in one accounting firm called the IRS. And in one fell swoop, I can do a withdrawal of all the accounts and terminate them all, because that's all these agencies are, different accounts. And do a special deposit and terminate them all.
Yeah, but that would be on an individual level, wouldn't it, Christian?
I could do it on an individual basis, or I could do it all at once, to all of them.
For everybody? I mean, you know, all the people in the United States of America?
Well, I don't know about doing it for everyone, because maybe it's individual. Each one has to have their own age of majority.
Yeah, that's what I was figuring.
Get out of there. Well.
Christian?
Yeah, go ahead.
In summarizing here, the guardian's trust is one of obligation and duty. Of the property entrusted to his care, he is to take possession, suffering no waste or destruction of the ward's land, and investing legally any funds belonging to him. And whenever the guardianship may be terminated, whether by the ward attaining full age or at an earlier period by marriage of the ward, by death of either ward or guardian, or by the latter's removal or resignation, a final accounting of the guardianship is to be made, quote, for the personal estate and the issues and profits of the real estate. To a minor who is a party defendant to a suit in court, there is assigned a protector known as a guardian.
Okay, it just said how to terminate
in the context of a trust.
Did it say how to terminate there?
Yeah, here it is. It says, of the property entrusted to his care, he is to take possession, suffering no waste or destruction of the ward's land, and investing legally any funds belonging to him. And whenever the guardianship may be terminated, whether by the ward attaining full age or at an earlier period by marriage of the ward, by death or of either ward or guardian, or by the latter's removal or resignation, a final accounting of the guardianship is to be made, quote, for the personal estate and the issues and profits of the real estate. So it's terminated by doing exactly that.
What is it exactly that it said?
Basically says that when you become of age, all the property that is belonging to you, that you have to you have to claim that property, and you can do that at full age, or if you get married before the age of full age, they allow an exemption, and that by that marriage...
What's the one we're looking for there? What's the one
merging of them.
We're looking for the age of majority where you make a claim for the final accounting and settlement. When you make the claim for final accounting and settlement, that is the age of majority. You just came to the age of majority right then.
The final accounting.
Yeah, when you make the claim for the final accounting and settlement.
Final accounting and settlement.
Yep, that's the age of majority.
It's almost like the age of maturity. In other words, when you come to a conclusion that there's a certain act that has to be conducted, therefore you get the muster up to have that actually occur, therefore you initiate it or act upon it, then that's the age of majority.
That's
you know, I'll bet that the original rites of passage to manhood is really, this is what this has been covering up.
You make a choice to go choose a wife.
Huh?
You make a choice to go choose a wife.
Hey, Christian, did you have a response on what I just said?
Yeah, that was power you were just talking about. That was the ability to make the choice.
Yeah. In other words, you actually took the you became the decider and acted upon that. Therefore, you actually are the age of majority.
Yep, you came under power. We're making it too hard. It's really easy. To terminate any agency, all you got to do is ask them or demand a final accounting and settlement, which is you're going to withdraw it from general deposit and redeposit it under the special. So they can't terminate the account unless they give you a final statement of accounting in settlement before they terminate the account.
But is it necessary to use the words terminate when you actually do that process? Or is it just...
I would say terminate, yeah, because this is a trust relationship and I want it to terminate, and that's a trust term.
Okay, all right, good.
Well, do you ask for the accounting first, and then you withdraw, and then put it in a special?
Well, this is kind of like colorable terms we're telling them, but yeah, actually what I'm doing is the withdrawal and redeposit. And that's under the private.
In trust language,
that would cover everything then.
Yeah, yeah. That's the same process I use for every agency.
But in our lingo, in our trust language lingo, if we use, I mean, what would be the difference between, in this case, the word terminate versus extinguish? Because you said that.
Well, I'm extinguishing a debt, but I'm terminating a trust. I'm not extinguishing a trust. I can't extinguish a trust. I extinguish a debt or an obligation.
Thank you.
I terminate the trust. Now, I can't
clear.
terminate the trust until I extinguish all the debts and obligations under it.
Okay.
I think we got the keys to go ahead. It's just that now we just need to come up with the correct verbiage. And we're not ready for that. I'm starting to see that equitable claim is nothing more than really, now when I find it in the CJS someplace, all we're going to have to do is just come in and make a declaration and then close the courts down. Because we're going to find out that we are equity. We are the right. There cannot be any enforcement against us because we are the power. We are the force. We are equity.
Are you saying that equity could be equal to a sentient creditor?
Yes. Who operates in maxims, not law.
That's very good. Thank you. I appreciate that.
But then he has to be operating from a standing of authority, and he has to be able to prove his authority because he has to have made the claim, proved the claim. Now he has standing in trust, and he has the right to close everything down.
But do you think it might be in our best interest to maybe consider following up with some kind of a declaration and or kind of paperwork to give that to the other creditors, which is the...
We've already got a declaration of independence. That's good enough, I think.
Okay, yeah, I know we've been talking about that, but I haven't put the final pieces of that one together in my head yet.
That's where it says that God has given us all unalienable rights. And it's all by nature's God and nature's God and nature's law and nature's God. There it was. Which really that's making reference to equity. Law of nature was equity and of nature's God. That's quoted right in the Declaration of Independence. It was making reference to equity.
Christian, if you were to put it in words separate from everything that I've been researching on the words of equity, which seems to be pretty blemished because of the modern day understanding or definitions, how would you size up equity in relations to the sentient being?
Equity in relation to the sentient being.
Without all the laws or stipulations or manifestations of ownership of properties and noble and titles and stuff like that, how would you size up equity in relations to, would it be like your personal relationships with God, your personal relationship with people, your personal relationship with what you want to do in your life? How would you size it up?
Well, I think equity, to be the age of majority or to be sovereign, is really to know equity. And to know equity is to know my relation with God and how I'm supposed to treat in relation with other people.
Very good. That's right on the money with what I'm thinking. You got any more?
Well, I mean, I could expand on it, but, I don't think it's really necessary, but...
Yeah, but that definitely hits it right on the nail. I mean, if you're a sentient being and you actually view manifestation as an aspect of creation of God with intent, then you serve a purpose for God being here on this planet. Therefore, there's your equity and there's your trust. You have trust with God, therefore you're extended with trust, beholding you to others around you, including manifestation, and that brings in the brother's keepers doctrine, it brings in husbandry, it brings in good faith towards others. The lineage is forever. I do agree with you, but I see where you're coming from, and I agree with it.
I think we've got it backwards. I think they're misconstrued God's trust that He's given. They're construing themselves to be the beneficiaries. No, I believe that we are the trustees of this earth, and God is the beneficiary of His own grant because He's doing it all to His own glory, to His own benefit.
Therefore, that goes with the token that every man is in debt to God for his existence, of which allows a person to either agree or disagree and be in service to God and manifestation, and or be a slave to it.
Right. So we'll use the Declaration of Independence. We'll close it all down from the individual master file in the IRS, or you could do it individually on a case-by-case basis. We'll terminate the whole account, create the new account, different name, no longer identifying or any closeness to the idem sonum, your name. Now there cannot be any connections or ties, and as long as you sign with a restricted signature qualifying who you are as operating, say, as trustee over the trust or in an agency capacity or an LLC, then you've got corporate protection. And as long as they don't commingle the funds and breach the trusts, and I do not interface back in with a business trade so that can be effectively connected with an income and taxable and become a fiction again, and then I can live my life in peace.
How do you view the true corporate soul, the one that actually is not infringed or abrogated by the government and or the IRS, the true corporate soul? How do you view, or have you wagered kind of like a decision on the difference between that and a true trust, or a trust that is created on the private side?
I don't think we need to have an operation of doing commerce in the public realm based on money, and money being taking. We need to do commerce on the opposite, which is giving. And our gifting needs to be the money or the medium of exchange. And if everybody's looking for how much they're giving instead of how much they're getting or taking, we would have a paradigm shift, and this humanity would be far advanced from what it is today.
A little bit like pay it forward.
Yeah, in a way.
Yeah, because I've been thinking about pay it forward. I try to work with everything that I do that I obligate myself with is always pay everything forward, and I kind of have noticed that is, for me, it's a rightful thing to do, although I'm in a world that doesn't doesn't work very well, but at least I'm trying.
Well, as Christians, we got to get a paradigm shift, and we got to get out of this mentality that we are working, because it says in the Scripture, if a man does not work, he does not eat. But what is the definition of work? today, man's definition of work is that you got to go to work for 40 hours and trade yourself, your hard-earned labor, for worthless pieces of paper. That's taking. So when we define work as being, you got to be a giver, and your giving is the currency. That's the system we need.
Well, I think sociability, and we hit on it just a little bit earlier, your relationship with God, and it doesn't even have to be anything different. You don't have to be religious about it. If you knew that you were in a paradigm, a creation, a manifestation that, I mean, my God, is there any other place that you can go that has the existence that we've got? We are, in particular, gifted to do your best in good faith and good nature towards other men, and manifestation means that you're husbandry and that you're part of society, and that whatever it's worth is to do your best to be a participant, to actively engage with making the best of it, to have a better world, because you never know if you've got kids or grandchildren or great-grand, or even if you're going to be reborn. I don't care what philosophy you got, but a better world instilled by your action is definitely takes precedence over anything else that I've ever seen, and that's trust to me. Setting forth trust means that you are going to do your best with the right psychology, the right spirituality, that you were given an X amount of time to do the best you possibly can on this planet, therefore go about it.
Yeah.
Of course, not everybody agrees with that. Of course, we already know that. But the thing is that if you look at our forefathers, Benjamin Franklin, Thomas Jefferson, you look at George Washington, and a few of the other comrades that were way back in that day, if you stop and listen to what Glenn Beck has got to say on his evening, he actually goes into some of the quotes that they talk about, and I just wish that we had more people like what happened nearly 300 years ago. These people were so inspired, and they were so just like right there with what it is that we're trying to elbow our way into this present time world that we live in, to have any say at all. These people, that was the going trend. That was everyday conversations back then for them. You know, talking about God and talking about manifestation, what you can do for your brother kind and whatnot. And nowadays, my God, personally, I feel like I live in a desert. I never know what's going to...
Spiritually dry.
I know, and I'm a good person, and I'm getting a little concerned because my life is on the line right now, and there's nothing else I can do about it. I've done well for a lot of people, and people don't have the same faith, and they don't have the same goodness that I do, and I'm being terribly affected by it, and I don't know what else to think. It's like, whoa, I've been a good man, I guess. I don't know. Good answer is.
Well, a good definition of work would be working is constant looking for the obligation or the opportunity to give. Work should be defined as constantly looking for the opportunities to give. That should be our monetary system today.
And I agree with you. Unfortunately, it doesn't pay my PG&E bill.
Well, we need to get into power and authority, and then start changing the laws back to what is it that's going to make a big change.
Yeah, I think that this is our year. I think that whatever we're going to sum up and put forth, and I promise you, Christian, I've only gotten just coming into the latest stuff that you've been putting forth in the last 6 months. But you know me, I'm a fast learner, and I've got a pretty good grasp, and I probably will start becoming a little more positively, constructively productive in this group. it took me a while to really grasp a hold of the concept and where this thing was moving, but because of the inner group members, including Jacob and JC and Eric and the rest of them, they have been very, very supportive on my development, and I feel very, very strong. I think that for some reason in my soul, and I can't talk for my personality, but in my soul, there's something coming up that's coming. To really give a lot of support and really start cranking out some of this information.
Well, we're going to take a shift into second gear at the Trust Ambassadors.
Is that right?
The core group, yeah.
Yeah, because there's something going on inside of me that's just yearning to beat the band. I don't know what it is, but when I get that feeling, it's usually pretty big for my life. And so I think that I'm there. I think that there's this part of me that it came up to the table, and I know what my duties and obligations are, and I will be probably pretty happy to follow through with all this, because what we're facing, if we don't do something, is not so nice, and I would rather go ahead and initiate getting her done, as they say. Get her done, and let's get this country back in the hands of the people, and then we can probably have a better life thereafter. But right now...
Okay, anybody got any questions on how to get into the Court of Equity, or...
Christian?
Yeah, Jacob.
It appears that the way to get into equity is really to have compliance from the judge.
I'd say recognition from the judge, for him to recognize my rights.
Recognize my rights. Okay. And in addition to that, we have to have a message of enforcement. Now, who is the greatest enforcer that we know?
The tax man.
Okay.
What respect you got? That's a very broad question. So.
Well, I mean, enforcement comes from authority, and what name carries the most authority that you know?
Yahweh.
Briberies.
I mean, I want to be a child marked with that name of authority. I want the element of power that comes from being marked by that identity.
All right, well, we're talking about a justification now, so unless you're justified, you are marked. You're either marked one way or the other.
Is it possible we could be marked in a number of ways as opposed to in just one way? I mean, we might be getting led into a trap by thinking that we're only marked in one way.
Not in justification. There's only one mark. You're either indwelt with the Holy Spirit or you're not.
I agree with that. Totally agree with that.
But really, I understand where you guys are coming at with that, but wouldn't it be a greater place that we all share the breath of Yahweh?
Yeah, but how did God design this? That's the thing.
Well, we know that he had many names. Adonai, Elohim, Yahweh, Iyah, Ayah, Ashur, Ayah. His identity was one of a cluster identity which had many ingredients.
For what purpose?
Well, each one of them was a separate purpose.
Yes, demonstrating what?
His character.
They were all demonstrating a different facet of character.
Well, demonstrating provision.
What was God trying to do by demonstrating his character?
But he took on a different identity for each one of those expressions.
So you could be looking and seeing just that, solely that, so he could just show you one side of him at a time.
Right.
But what was his whole purpose? All the names of Yahweh are wrapped up upon one name. And that name is the Messiah. All the names of God wrapped up into one. For the purpose of teaching you who God is. That's all he's trying to do. That's the purpose of his demonstrating his character.
But when you go in front of the judge and you make your identity known and your law form is the law of Yahweh, he's going to want to know who that is because you're making an aggressive demand for compliance.
But we have such godly courts. They don't have the wisdom of God, which is the fear of God.
So Jacob,
they do not know who he is.
Jacob, why would you use the word Yahweh when all you'd have to say to a judge is the creator of manifestation, which kind of leaves it a little more coherent in understanding than using a word that maybe 90% of the world doesn't understand?
Well, I would use the word the creator because isn't that the word that's used in the Declaration of Independence?
Well, yeah, but what I'm saying is you're using words and you're putting it out there for Christian to answer you based off the words that you're putting out, and you would never walk into a courtroom flinging around Yahweh because until a couple of years ago I had absolutely no idea what that word meant, and I've always referred to God as a creator or manifestation or God or one thing or another, but Yahweh threw me for a loop, and it took me about 2 years to understand that somebody was trying to refer to God as being Yahweh. And and if I was a judge and I heard you say that word, I would probably feel the same way that I felt for 2 years. I'm not trying to put you down for using that word. I'm saying it's
I appreciate your viewpoint 100%. Don't worry about that. But the point I'm trying to make to everybody is to let everybody consciously think together so we don't get fooled again. A lot of you people got fooled for 20 years in the debtor-creditor movement. You guys thought you were right on for 20 years. I never fell to that. And we don't want to fall just because we get too set on something that we don't know with 100% proof that that's what the thing is. And I just see that Yahweh has, he has a cluster identity. What if, in fact, for an example, what if your birth certificate wasn't even an issue with these guys, and they actually had a secret birth certificate that they never even showed you that is actually the real deal? And you're going to go after something that they put as a false carrot out in front of you. I'm just trying to be more careful and trying to think, just add to the conversation that maybe there's another side of this that maybe is going to reveal itself as we go through time, and maybe there is some kind of a, because we've talked about tutors and curators and predators and all these different steps that they've obviously taken and written the IRS code around it. All the IRS code I can see is taken from that.
Yeah, but that's 63 million laws of confusion. Laws of confusion.
Chaos, the master plan of chaos.
Yeah, but that's not the only thing. You know, Jacob, when you go in front of a judge, you know what a judge's cheat sheet is?
It's what?
You know what a judge's sheet is?
A cheat sheet?
It is a cheat sheet. What they've got printed out is your whole history since you were in elementary school, and even prior to that, from your birth. What they've got is a printout of all your activities and all your credentials, every little nook and cranny of everything that's happened in your lifetime, that allows the judge a profile to see the progression of your life up to that point of that courtroom, and that's sitting in front of his eyes when you're standing in front of that judge.
Well, my sheet's going to be blank.
Well, I don't think so, brother. I'm telling you right now. You can't fool me. These guys have got the most intricate details in your life right there in front of them while you're talking to them at the courtroom.
Okay, and so that does what for the guy?
That allows him to size you up with what they can get away with and what they can't get away with. It allows them to understand who you are, what you're about, and whether or not they're willing to take advantage of you or they know better from your past. That allows them to know if you're an alcoholic or a druggie or you're a loser, or you've been through college, or you're a CEO, or that you're a public officer. It allows them to understand how much bonds are placed on your name as securities that give you value. It allows them to understand how much you're worth. Everything that's happened since you were a baby. They've got a history sitting right on their desk in front of them that sizes you up while you're talking to them in the bar.
Okay, so what is the name of that record?
That is a cheat sheet for a judge. That is exactly what the printout is from the secret, whatever you want to call it, the IMF report or the IRS report or securities report on you and your life. It gives you everything on that. I've seen mine.
Really?
I accidentally got it when I terminated my attorney. He handed everything, including that, back to me, and I said, "Oh my God, look at this!" They had every. I had no idea that they had a history like that on me. I had no idea that they had that many details on my life. I forgot half the shit that they had on that list, going back since I was a baby.
Okay.
Once they see that, they see how they, like Chris said, to size you up and how to deal with you. But what's very interesting, majority of the people in this country, 99.9%, they do have that record. Now, what's interesting, when I went in front of the judge, they didn't have that record. They didn't know what to do with me. Now, I'm a very small percentage, but the majority of the people, they have this record in front of them, and they size you up. But what is interesting is that because they have this record, and then once we go in there and we change the IMF, they're going to see that. And I think that that's going to be a sign to them to say, okay, I know who I'm dealing with now.
That's exactly the reasons why I'm pointing this out is because these guys don't care, other than the fact that we have the power and the knowledge to go in there and correct these records. That shows they were age of majority. They're going to recognize that more than anything else. That will expunge the record from the past and allow us to have a clean slate, just like what Christian's been saying to us. I totally, absolutely believe it. Because I just shared with you part of what I've known in the past, is they've got this cheat sheet that they've got every little nook and cranny of everything that's happened in your life right in front of them, and they're judging you based off of what they're reading.
So if we do a statement of final accounting and settlement of that whole master file, then we achieved the age of majority. And it's welcome on in, boys. We finally made it.
Now, let me give you guys one example, so one for the record, that you can call me on later. But as an example, everybody I hear talk, they talk about the IMF or the IRS, okay? I happen to have some information myself that the so-called IMF is kind of like, it kind of led you to believe that. And so I'll give you the information so you guys can all check it out. But what if it's not the IMF? What if it's the business master file as opposed to the individual master file? So I would challenge you guys to go look up, start going in that direction of the business master file as opposed to the individual master file. And I'm just giving that as an example to show how, you know, how easy it is to think that you know that it's the IRS or the IMF, and in actuality it could be something else.
Well, you're right about that. The IMF is the public side to the U.S. Treasury and the Bankruptcy Act. That's true. I agree with you. They are a true creditor just along with the U.S. Treasury. There is a superseding file on you that is exempt from that particular authority and that set of statuses. There is a master file on you that's separate from all of that. I do agree with you, Jacob. Don't think that that all of us out here don't know that there's more. What we're trying to stay with is creditor status and how we can, you know, go about finding out our creditor position within all this stuff.
No, I'm just using that as an example for everybody to show that maybe there's something more that we need to work on in the area of our identity, our real identities. When we do the statement, final accounting, and settlement, we want to make sure we're doing it on the right party or entities that they, you know, maybe they duped us into something. And you could be doing it on the wrong thing, thinking that you're doing it on this particular way and that you're getting this thing that you're actually, you know, going after, but when in fact, you know, you did it on your individual master file, and you should have done it on your business master file instead, as an example. Or you did it on your birth certificate.
You don't have to mention files specifically or not. All we have to do is ask for to terminate all the records, period.
Retaining or relating to such and such number and birth certificate number such and such, because that's what they identify of. You know, whether it's a business or not, we know that they turned it all into a corporation. Of course it's a business, but we attach those numbers to it because that's what they identify us with. Where are your papers, please? And that's the number that they look at, or numbers.
Really
well, there's going to be there's going to be a. Excuse me, just for 1 second. I wanted to follow up with something that was said a couple conversations ago. There is no way that they're going to erase records completely. They may deactivate it or take you off a standard of being active within a certain authority or jurisdiction, but they're going to keep records forever. I've already been told this, that they're never, ever going to get rid of the records. So there always will be records regardless of what we do. If we deactivate and or get out from underneath their jurisdiction, we're exempt. From there on out, our records may be clean because they cannot harness or make us subject to certain jurisdiction or authority. But from what I understood, and I've questioned these guys, they're adamant they are not going to release or they're not going to expunge our records since our birth. That's a done deal. I already checked that one out, and it's hardcore, but, you know, that's the way they said it's going to be.
Anybody else? Shane, you on? Shane, are you out there? You've got some questions usually.
No, just kicking back, chatting here in the background, and I think you guys are doing pretty good.
Certainly a spirited call tonight. Different than usual.
Yeah, if I can't beat it, I'm going to join it.
Well, get your licks in while you can, because we might be signing off here shortly.
Oh, I don't know. I'm just, I'm not sure actually if maybe a summarization of what everybody's saying actually, because there's a lot of people throwing a lot of stuff in here. I don't think I can really add anything. Like, I mean, I don't really have any specific question. I'm just listening to what everyone's saying, but it sounds like the punchline is like to just say no, or actually I would relate a story. I've got a video of a guy, a Canadian guy, and he just disappeared. Like, I mean, I don't know where to find him. His name was Gord Schiller. And I had an experience where he was trying to go into court, and he said he was trying to be nice because he's trying to get something done, and the judge said, you know, just go sit down there. And as soon as he sat down, the judge nailed him with the bailiff and all this stuff. And so the next time he went in, he learned from experience, because he tried to say, I'm sitting down at my own free will and all this stuff, but it was his actions seemed to override. So there's actually a lot of interesting information there. But the next time he walked in there, and I ran this by somebody else, and they said this was perfect. They said he walked in there, and the judge said, well, just go do something or whatever. And he turned around to the judge, and he said, I don't take orders from servants. And apparently, like, the judge started freaking out, and the bailiff of his own accords tried to come down and grab him again. And then the judge ran over to the side and started waving his arms, saying, don't touch that man. Just let him do whatever he wants. Like, totally went from polar opposites of, like, threatening and doing that technique that they do to literally saying he was white-faced and waving his arms, saying let him do whatever he wanted. And I think that's kind of similar to just say no. This idea of taking, I mean, Sam Kennedy has said it too. He said it took him 4 or 5 years before he really grasped the idea of taking control of that court. I still don't, you know what I mean? I know about it, but I don't want to do anything that I don't completely understand myself.
Yeah, I would just say no. I would say no. I don't grant that.
Yeah. And then apparently that puts a presumption of yours in place, and then the judge has some kind of puts him in a tough spot because he has to now disprove your presumption, apparently. Like when you get it, when you say something like, I don't take orders from servants, or I don't grant that, you've created like your own presumption that they have to specifically override or something. That was the logic somebody was trying to explain to me when I ran this story by them. So I wonder if that has something to do with it. So that's all I can think of right now, in line with what you guys are hitting at.
Well, I'm looking for the proof that I need in somewhere, corpus juris, I hope, that would prove the fact that, you know, substantiate what I think is that we do not even have to go into court. We could just put the court on notice after we've done a similar thing like what that 4 pages that I talked about, that show cause, public show cause, that would be a declaration, and that would just put the court on notice, and that I don't think that you have to even appear.
Christian, if you were to give the court notice and you gave the opposing party notice about the trust information, by giving them notice and it stood for 30 days without a rebuttal or objection by the opposing party, in other words, they didn't go to court and try to do an ex parte or had any kind of a hearing on the matter, that means that those documents would stand just like a affidavit or a declaration. Is that correct?
Yeah, declaration, yeah.
No, that's not a bad angle. I like that. That's pretty reasonable right there.
Declaration is one method of formation of a trust. So only the real man can declare. So the real man, he's the only one who can form a trust.
If you'd like to ask a question, please press 1 to add yourself to the queue. Otherwise, press 2.
That stick in a courtroom, if you were to give notice to the court, say for instance you gave notice to the county recorder's office saying that these people have been defaulted administratively. We have went ahead and filed like a lien of some variety on a UCC, and 30 days elapse after the notification. There has been no rebuttal or objection because you've given them a CC copy of it. That they never came to the county recorder's office or the judiciary, the DOJ. Therefore, your statements and or affidavit or declaration stands as fact. Therefore, they can never show up in a courtroom anyway.
Yeah, they would stand in equity, yeah.
But isn't it 30 days that they have to respond? Otherwise, it's a done deal on its own merit?
Or commercially, 3 days.
3 days? I thought it was 30.
No, commercial is 72 hours. And everything is commerce in the public anyway. Usually they try to drag you in 30 days within the time they cite you, so you have barely enough time to go ahead and do that. You'd have to have it done almost right at the same day. And so I think you need to beat them to the punch. You'd have to go the commercial route probably. Anyway, anybody else questions? So it's getting late.
Christian?
Yeah, Jacob.
Have you ever taken the word or the concept signature all the way back to Genesis chapter 1?
No nature?
No, it says they state it like this. They say, these are the records of so-and-so, okay? And we're talking about records. I think it's important to understand the origin of records. And so the word used there for records, it was translated as origins, histories, births, decedents. You know, it's possible to translate it with histories as part of a title over stories, and with generations or descendants as part of a title over genealogical list. So I was just thinking that originally records referred to origins, histories, births, descendants. When they used the word records, it was complicit in all these things, and now we're picking apart and doing a specific record here and a specific record there. And when it comes to our rights, you know, it must have something to do with the original records and the concept of these records to be, you know, it's really hard for me to express what I'm trying to get out, but where a record contains an origin of the record, a history of the record, a birth of the record, and a death of the record. Just trying to give some more support to maybe there's something more to all the terms that we used for guardianship and wardship and all these things, that there's got to be some original foundation for where they took all that from. Just
well,
like...
I mean, where they got the authority to make the records?
No. when these records were recorded when records were actually recorded, the first records ever recorded, they were broken down, and there were headings on subsequent parts, and they were originally on clay tablets, and the phrases replaced on the copies, the seal under the original, so there were not titles over the subsequent parts, but the signatures were under the preceding parts of origins and histories and birth and descendants. And somehow we're dealing with merging titles, and we're dealing with a signature, and I just think we might be able to find some kind of, there's got to be some unknown things in this area that we, over the next, long study period, that might come to light.
Well, when you find them, you let me know.
Okay, I'll do that.
Anybody else?
Yeah, Christian, just a quick question. When we're creating documents to do the merging of the titles and whatnot, is it possible that we can actually put at the top, you were talking about the mandates of injunction? Wouldn't that be kind of a lawful legal term on trust levels to put an estoppel to any furthering actions to maybe foreclose and or shut off services, keeping your credit clear or clean?
I'm not quite following you.
Oh, you had mentioned a couple different times, not just past, about mandate injunctions.
Mandated and mandatory injunctions, right?
Yeah. Can't you kind of universally use that for several different situations under the documents and stuff that we're creating?
For enforcement, yes.
For enforcement, is there do you read off a stat that backs that, or is it just the quote under maxims of law? Where do you come from with the enforcement power of that? Excuse me.
The Court of Equity is going to use that device to order them, and it looks like, from what I'm seeing, that we're the one issuing and giving the orders and doing the granting.
Okay. So in other words, if they fail, in other words, let's put it in kind of a scenario. If they fail to act upon your order as grantor or settlor, and you put in a mandate injunction, and they went ahead and worked against that, therefore that becomes a damage and injury that goes back into statutory law, right? Or is there how would you deal with a situation like that if they went ahead and breached the trust on that level?
You have to come back in and apply to the conscience of, say, their courts.
You would have to go back into statutory law or at law, right?
Yeah. Yeah.
I think that's where a lot of my questions have been recently is that, okay, fail safe, what do you do if they don't act upon that?
We'll have to go to a higher law firm then, which would be, say, the next court up above, and see if we can get some kind of enforcement on the lower court that's not, kind of like an appellate court, next higher court.
How do you weigh in with 3 notaries? I know you had mentioned it the other night that you found confirmation of a few hundred years ago. How do you weigh in with being able to use 3 notaries as an appellate court, or how do you feel about having several people sign on a document as a petite grand jurist or something like that? How do you weigh in on that stuff?
I don't know, but I know the notaries is the panel that's going to probably give you an estoppel under res judicata. It's already been judged. All you're doing is notifying these inferior courts that here's the order. This is the hand down resolve the order.
Anything that we do, it would be our best benefit to go ahead and have 3 notaries sign off on it. Therefore, we have an appellate court right there that's completed it.
Yeah, if it's probably along the same kind of government that what we're talking about, yeah.
All right. Well, what about signatures from, like, sentient beings? I heard that 3, 6, 12. I've heard that those actually stand in lieu of 3 notaries. Have you had any input or any, do you have anything you want to kick out tonight on that one?
If these guys don't really do what you're ordering to under justice, under equity, under equality, under fairness, then I can always come at them commercially. If they don't have a bond, I can give them a bond and I can liquidate the bond.
Okay.
They're all bonded in commerce somewhere.
Yep.
And they all all those bonds can be distressed. All those bonds can be arrested.
And would you use would you create a new trust to have that occur, or what? What would you do there?
I might. Yeah, you could use another trust to do the enforcement through. But I would liquidate those bonds. And those guys would be commercially not viable.
Well, what if they're self-bonded, which is unlawful here in the state of California, even though they do that? They're, from what AIG has said, that they are functioning as a government here in California without properly or lawfully being bonded. Therefore,
great. I love that. I'm going to give them a bond then, and then I'm going to liquidate it.
Oh, I got it. Yeah, it just dawned on me what you're talking about. Okay, all right.
Yeah, they can't run, they can't hide.
Isn't that what Mick Jagger said a few years ago back in the Vietnam days?
Yeah.
There's nowhere to run or there's nowhere to hide.
Right.
Well, okay, so what kind of a bond would you use in a situation like that? Would it be a surety bond? Would you just post that, or?
An indemnity bond, and they breach the bond. I liquidate the bond.
That would be a performance indemnity bond, right?
Yeah,
Because if they fail to perform in the duties and obligations of their said office based off of the prescribed oath of office, therefore, if they fail to do that, the bond stands to protect you for the outcome of the case, right?
Right. Their Achilles heel is commerce. That's their Achilles heel.
Good. So is there a way?
Oh, I'm sorry. Go ahead.
Well, I was going to say, is there a way to use what you guys are talking about as judicial compliance when trying to get into a court of equity?
I had designed a plan to take down the whole judiciary. All we need is about 30 people. You can take it all down all at once in all one state.
Do that by state or what?
Yeah, about 30 people per state.
I can certainly help you out on that level. We got a lot of disgruntled people in California.
Yeah, well, let's get standing first. Let's get an authority so we can use our power and do the enforcement.
Well, the average ticket nowadays is $800 here in California.
That doesn't pay the judge's lunch.
I know, but that's the average cost of a ticket here in California right now.
Yeah, what's the bonds running in the background? What's the bid bond, performance bond, payment bond?
Well, that's into the millions, if not billions.
Isn't it not 440 and 400 million on a local, state, and a federal? And then you got 3 bonds times 3?
Yep. Hey, did I tell you that I found out the EIN numbers of the state of California Superior Court has an offshore account? Did I tell you that yet?
Those are all liquidatable.
Yeah, but did I tell you that the Bar Association for the State of California has an EIN number that's located on an offshore account that is the same account that the Superior Court of California has?
We've got so much money on the public side that is stashed away in CAFR funds and different trusts and stuff, and then they make it look like that this country is broke. It is not broke.
Well, this country's broke because they took and put it all in the offshore accounts.
Yeah, they're not. That's with the assets that they've got.
The money's still there. See, dollar for dollar, whatever money's there is still there somewhere, and a lot of people are just so brainwashed.
None of the assets have left this earth. They're still here somewhere.
That's what I said. A lot of people think, well, it's gone. No, it's not. It's still there.
It's never left this earth. It can't leave this earth. Everybody's got this wrong thinking, this thinking. They're not thinking all the way through to the bottom of things.
Christian Winston.
Total of the assets of this wealth of this earth has gone nowhere. It's still on the surface of the planet someplace. In fact, there's untold wealth that we don't even know of in the center that we haven't even got to yet. We just scratched the surface.
Well, from what some of my research buddies that are kind of like, I don't know, I kind of question them, but they come up with some very ingenious stuff. They say that they've worked for the U.S. Treasury and stuff like that, and they say that just like what I think it was Shane was saying is that I can't remember if it was Shane or somebody else, but that there are other CAFRs. There's other coffers and CAFRs. One of them of which is the Vatican, and there was a confirmation that came through one of our groups that was able to have access through the U.S. Treasury because they actually worked there, and they had the ID that was necessary to be able to get access to the gold reserves that are waiting for us as individuals that have our own stamp embedded into the gold bullion, waiting for us to put claim to it, and they got me so excited that I didn't know what else to do, and then all of a sudden I lost contact with them. But that wasn't the only source that actually brought that information forward. So it kind of like, it struck a nerve with me to think that we're all swimming around in the lower part of the totem pole here, and there's a whole other threshold of stuff going on that if we were just to get our hands on the information and grow to those other echelons, that we can really certainly get our hands on some wealth that really has substance to it rather than fooling around with all this paperwork crap,
All we need is the titles.
Yeah, well, there's got to be something about it because going back to 1933, you're going back to 1860, you go back to 1812, you go back to 1794. When you look at these marks, historical marks of where things had changed drastically, even the Treaty of Oregon. The Treaty of Oregon, from what Keith Levingway was saying and what the research brought out, is that if it wasn't for the Treaty of Oregon, we most certainly would probably still be on the standards of what the Constitution dictated. So I haven't gone and researched the Treaty of Oregon, but there had to be something so monumental that gave precedence to the British Crown for them to come in and clobber our congressional government. And because it was just recently reported that there was a default, a week before they completely defaulted the square 10 miles of Washington, D.C., that was a week before BP did their thing down there in the Gulf of Mexico. So there's got to be something going on there that the general public doesn't really get hold of. But it doesn't surprise me that the British government's got a handle on everything that's going on in this country at this point.
I'll take that last comment I made back. It's not that we need the titles. We don't need the titles. What we need is the age of majority because we already got the titles.
Have you actually read the 13th Amendment? Have you gone through that yet and kind of dissected that?
Hey,
yeah,
Chris.
Many years ago, yeah.
Chris.
And what is your bottom line conclusion about the 13th Amendment in relations to trust? Because it seems very, very similar.
I'd have to read it again. I forget what it says. Really.
If you need a source of the original book, I've got people that found the original books in archives in old libraries that were abandoned. They found original copies, and they sent me copies of the original stuff. If you want a copy of the original stuff, I should be able to find it in my files and send it off to you.
Lots of stuff.
Sir?
Somebody was saying something there. One on.
Well, Chris said something interesting. He said general public. And here we are is getting rid of the general deposit and put it in special deposit.
Right, right.
It's always been there. It's always been in front of us. We have been too blind to see.
Like walking on the dirt, you never know it's there.
That just goes to show that, you know, when I walked out in my backyard this afternoon, it dawned on me how precious it really is to be in existence, because when you look around eons and eons of millions of light years away, there is no life existing anywhere close to what we are. And how precious it is to be in a human form here. You know, you can't take anything for granted, and that means that you can't be mechanical. For everything that comes at you for every given moment, you have to deem that as being the most precious thing that ever was given to you by God. No matter what exception it is, you could be dealing with law, or dealing with your animals, or dealing with, you know, in jail. Everything has a precious moment, space, and time that is a gift for you to take an opportunity of.
Agreed. Very profound.
Yeah. The Hindu religions actually look at every second as being, from some points of view, every second is millions, and in some cases is billions of years to some other level of existence. That means that when we're existing and we bypass a second without even thinking about that second, we're floating on that whole scenario of all those different levels of existence in time and space going by without our recognition or acknowledgement.
Well, we're not tapping into this conscious existence even as much as we probably could be.
I think a lot of what happens to me is that I try to buffer that and try to get out of existence. And this is the beauty about what Christian's been trying to teach us, is even though it may be inadvertent with what he's trying to teach us, but he's trying to teach us to get back into time and space and actually own the moment. And, you know, if you go to Eckhart Tolle or any of these religious or spiritual leaders, they try to get you to free yourself of the pain and the suffering of what has been in your imagination about the moment, really actually be able to act in the moment. I think in a lot of respect with what I've learned over the last few years about spiritual development, I think that Chrisitian Walters has hit it right on the nail. Let's get down to brass tacks. What is it going to take for us to act?
I'll tell you what I'm trying to teach. I'm trying to teach that there's three dimensions to salvation. There's justification, the first dimension. Second dimension is sanctification. And the third dimension is glorification. And I'm taking the second dimension, sanctification, and showing you how to apply it in your life and live it.
Acknowledgement of that. That's what I was blessing you with.
I've never told anybody that, but that's what I'm doing.
Yep, and I totally, absolutely get it.
Sorry, Christian, what are those three elements again? I heard I just kind of caught the second one mostly.
Dimensions. First dimension is past tense, which is justification. Second dimension is sanctification, which is present tense. And the third one is glorification, which is future tense. The three tenses of salvation: past, present, and future. Justification, glorification, and in between, sanctification. Each one of them is in separate compartments and cannot be commingled.
But they're in trust. They have a relationship with each other.
Yeah, so all I'm doing is taking the second dimension, sanctification, and applying it in a practical application and living it.
And that's the sanctity of our own selves as conscious living souls here in this physical form.
Well, there's a relationship with depravity, the total depravity of man, and the laws are really supposed to be the tutor leading you to that you need salvation. But today the laws are corrupt, and the laws are leading you to commerce, to worship commerce.
Right.
The laws today are not designed to lead you to God.
Yeah. Well, you know what? I was just looking back, and it's taken me years and years to realize, like I took psych for 4 years, and we learned a lot and all that crap, but they never discussed consciousness in the institution, because that's what I was, looking at the time. I was interested in altered states and so on, and it was a non-issue. It was like behaviorism was one of the biggest movements in psychology in the U.S. especially, and so the criticism was like you're studying psychology without the head, and
it's a great ontological question. It's a great ontological question. What is the meaning of God?
Yeah. Well, I like going to what Alan Watts talked about. And God was sort of like the complete totality of everything, in the sense that and that actually goes into the quantum physics and Max Planck and all of that. We're just each an individual, sort of a faucet or expression of God, perhaps.
You know why I love Christian Walters, and I'm going to tell you straight off, is because out of everybody I've listened to in the last 56 years of my life, Christian Walters is probably the closest one to what I've always thought life was all about, and that is relationships. What is your relationship with manifestation? What is your relationship with yourself? What is your relationship with the planet? What is your relationship with people? What is your relationship to government? This is what trust is all about. When it comes down to it, trust is relations. What is your relationship with that? And when you say that I have no relationship with that, that means that you're exempt of it. This is where a lot of people have misunderstood what a person that is supposed to be sovereign says that, well, with this present time government, with all their statutes and all their regulations and their codes and whatnot, I have no relations to that because I've never been asked if I have a consensual agreement with that. I have no relationship at all. So therefore, it's a trespass. But when you start creating trust, that is a person-to-person or relationship-to-relationship, even if it was with God. And if you do it right with what Christian's talking about, you set your parameters as priority with God or manifestation. You're doing God's work. You're your brother's keeper. Whatever way you want to look at it, whatever way you want to have that drop down from God's will, you're having God instill you.
Who is the greatest in the kingdom of heaven?
Yeah, and so therefore everybody you touch is like magic. He gets it. Everybody changes.
Maybe not everybody knows, but who is the greatest in the kingdom of heaven? He that does the will of them all.
I am that I am.
That sounds like trouble.
The lowliest servant, the server, the one who serves, essentially, that principle.
Well, I know I'm a brother's keeper. I've been a brother's keeper for as long as I can remember. It's just that as I get older, the more that comes out of me is to realize what's the most important thing in my life, and that is to serve God and serve humanity. There's nothing else that's more important. Yes, I'm poor and I'm broke and I'm about ready to go out of business here at the house. But the thing is that I give everything I possibly can, everybody I possibly could, and just because things didn't come back for me, I don't know if I did something wrong or one thing or another. But the good thing is that I have a clean heart. I have a clean soul. I know I've done my best for God. To get this country back.
All you need now is somebody to wash your feet.
Huh?
All you need now is somebody to wash your feet.
It's time to go to the beach?
Put some oil on your hair.
Actually, to tell you the truth, this has got to be one of the finest, the most happiest times I've ever been on any of these calls, Christians, with your calls. I have to really say that I feel like I'm part of a part of a family here of people that you can really just sit down and talk about this stuff. And I really have grown in the last 6 months, and I've really got a handle on what it is that we're doing here. I really can't wait for the next few months to see what we're going to come up with here. I think we're really truly onto something here, and it's bigger than what.
It's not going to be in the next few months. I think it's going to be in the next few weeks, because I think everybody's ready.
Oh, yeah, that's fine. I mean, I think that there's other things that are in the workings, too, that are not part of the CW's that are in the workings, too. And I'm very aspired to be part of those programs, too.
I think, too, it's a constant exercise of our understanding of truth. That's the only thing we got to be vigilant always, to be going back and checking and double checking and never stopping that process as well, because that always brings more understanding and more levels of thought and keeps us, you know what I mean? It's a dynamic living kind of thing in some sense.
I've got one last question for you, Christian, and then I'm going to call it a night. What is the bottom line? What is your summation? Because you've been asking everybody about how do you get into a court of equity. Can you give us your absolute bottom line in one summation right now of what it means to you to get into a court of equity through the normal jurisdiction of a court?
Well, I believe I'm already in equity, and all I have to do is declare it and give everybody notification.
And that's without the court standing outside giving them just notice? Is that the bottom line?
Right.
Okay. And would that include some of these mandates of injunctions and stuff like that, that language we've been learning this last few weeks?
If I had to enforce it, yes, I'll be using those.
Okay. Otherwise, you'd be gentle and just giving them notice that this is the way it's going to be, that you are the grantor or settlor, and that you never had intent for these criminals to get away with what they're doing, destroying.
Right. I'll forgive them if they repent.
Yeah, what's up with that whole thing? I mean, is that just an easy out for them to go ahead and agree with it? Because I have a little bit of a hard time chuckling that shit down.
That's a fundamental principle of.
He who gives forgiveness, whoever sows forgiveness reaps forgiveness. So.
Yeah.
I don't want to be the one who's the implementer of God's justice, because whatever a man sows, he reaps. Yeah, but if necessary, as corporate body, yeah, I will go to war.
Every man has an opportunity to repent.
Yeah, but you know, I was always trained,
be forgiven.
I was always trained to be a private attorney general, and that comes with a lot of power.
Well, this is the whole thing. The Roman system is designed so that we live in a society where the idea of forgiveness is punishment. And I mean, you look around you, and it's bastardizing the whole principle of Christianity or spirituality. Everybody denies it. Everybody wants to pretend they're perfect. Everybody gets away from, because in court, if you say, oh, yeah, I'm sorry, I made a mistake, then it's like, great, thank you. You gave me grounds to sue you, right?
If you'd like to ask a question, please press 1 to add yourself to the queue. Otherwise, press 2.
Do you think that the way that the declaration that the Restore America put forth, it was beautiful. I mean, it included the language of forgiveness and whatnot for the ones that would rather repent and come back onto the side of Republic. But for those that did not, then they would have to, reap the wrath of the military and whatnot. Did you guys see that? I mean, did you read the declaration that was put out by the Restore America?
The rain will cease.
Yeah, one way or the other, I agree.
But just simply in truth, if somebody does something and then they come forward and say, I made a mistake, I want to correct my error, how can you not forgive them? You know?
Well, I certainly would.
Argument.
Yeah, I would have no problems with that. But so little comes forward and does that. I mean, probably less than 1/10 of 1%.
Because we're conditioned by this materialistic, this Roman system, I think it is. And it's in the corporates, it's in your job, it's in the courts, it seems, if we're in statutory maybe. It's the way lawyers think. I don't like the way lawyers think, you know. I don't want to be a lawyer. I always say to people, I want to be the antithesis to a lawyer.
Matrix,
you know what I mean?
Matrix is everywhere.
Yeah.
Oh, yeah.
Out your window, when you go to church. When you
Secular
get up
churches.
It always starts with 1.
You know, one good thing that I have learned, and that is before I go to sleep, I unplug everything in the house. Everything gets unplugged. I know that people feel inconvenienced because they can't get a hold of me, but there is a harp energy that gets played out through these mechanisms, and their services that they pump into your houses. You guys might want to do the same. I have not rested until I started unplugging all this stuff in my house, and as soon as I did that, there was peace in the house. So you guys might want to be a little conscientious about that.
I would agree to that. There's a guy, what's his name, Michael Persinger, and there's a nice video, and he talks, he's a university professor. Well, I think he was born in Florida, and he's done contracts for the U.S. military, and he talks about altered states of consciousness and drug effects and so on. But he also talks about that electrical frequency. That's what he's famous for, is the helmet that you put on people's head. That's fine electro frequencies. And he actually said, I wouldn't normally believe that, but he did state that this could very easily be built into radios and televisions and all this stuff. And he's like a 30-year veteran professor. He's up actually in a university in Thunder Bay in Canada. It's almost like he's hidden away. Why would a guy with 30 years tenure be up in Thunder Bay?
How do you guys know that I was trained to be a teacher for a psychic institute, and what we did do is out-of-body healings, and we did out-of-body travel as groups. And so, therefore, I'm well-trained with knowing and being very sensitive without the body. And when I sit here hovering in the house, looking at all these energies, it just blows me away with the influences that come in certain ways that set frequencies. And these frequencies come with these astral belts. And I don't know if you guys know what astral belts are, but there are certain types of influences that harbor in and around frequencies that are subject to your body while you're sleeping. Therefore, you feel on a body level that these things are real. And so therefore, you wake up and you feel like, you know what? Well, guess what? You have just been hit by this stuff that is your technology that's in your house. So I'm just giving you a fair warning.
Did you guys experience the blackout a couple years back, a few years back, when it went out for like 2-3?
Q&A session is over.
Hey, you'll have to unmute now to come back on.
Thanks, CW.
Anybody hear me?
Yeah.
I was just saying, yeah, when during the blackouts, people say they notice much more.
Muted. Unmuted.
There you go.
Muted.
All right, unmute yourselves again. Try again.
All right, that's the ticket right there.
There we go. Okay. All right, I'm going to go, guys. I'll see you later.
Hey, Christian, thanks so very much. You are, you're so impressive. I'm so happy with all the research and whatnot. And some of us are finally starting. I know that I can speak for myself. I'm finally starting to catch on exactly with where everything's at, and I definitely are in for the long haul to get this stuff done. So you can count on me, okay?
Okay, I appreciate that. Thanks for the good comment.
Yeah,
Yeah,
hey, Christian,
Yeah, Jacob.
thank you very much for sharing your heart.
All right.
Night.
and soul.
All right, good night, all.
Yeah, good night.